the party appellant and state is appellant.
Pardon, my lord.
Mr. Kuntia was arguing that
It will be there at 2 p.m.
solution-
You'll see.
Yes,
Your matter will be taken up at 2 p.m.
my lord.
Pardon, my lord.
53 items, 29 items. Already we have 2 matters.
All right, we will see later.
My lord.
Pardon, my lord.
Let it reach.
Yes.
Pardon to mention, my lord, on content matter, my lord. On content, second content, my lord. My land has been acquired by the government official, but till today I have not get any compensation, my lord.
No contempt, no urgency in contempt. All the contempt matters we are taking up, all the contempt matters shall be taken up. We are of the opinion that they shall comply with all the orders within 2 weeks or 3 weeks. This is what has been assured. Please wait. When a time will come when we will take up only contempt matters.
So my friend can give his number so that I can also look at
Yes,
my level.
please. All the mentioning, contempt mentionings can be met before him.
Pardon, my lord. Petitioner sister died. Petitioner sister died. To attend his sister.
What happened?
Petitioner sister died. Listed tomorrow.
When, which matter?
BLPL number 1416.
Here BLAPL is not.
Sir, interim application has pending 366 to 2024.
Make a mention before the honorable.
Kindly listed tomorrow with
You are mentioning bail matter. You are
Yes.
mentioning bail matter.
Yes.
You have to mention before the assigned bench, not here. Is it division bench matter?
Yeah, interim application has been pending. This honorable court.
Are you practicing a lawyer?
Yes.
You practice here? Since when? Huh? We have doubts.
Bail court mention bail
Did you join any chamber, Mr. Counsel?
I pending.
Maybe tied up
Tied matter.
It's a tied up matter.
Yes.
It will be listed. Don't have to make a mention.
Tagged up to which matter? Tagged up to? To which case it is tagged up?
Mr. Counsel, did you join any chamber after joining the profession? We are worried about it. You joined the High Court about 6 months ago.
Yes.
You are making this mention which you should not have mentioned. There is no problem. When we were 6 months at the bar, we were also not knowing all these things. Possibly your senior could have advised you. Just talk to some senior and then do whatever is to be done.
He says, once your lordship heard this matter on a Friday, a bail matter, so must have been adjourned. That's why he's saying it's a tied up matter. It can be listed before any other regular bail.
Can we listed?
Interim application for interim bail.
Give your slip, we will see. Please give your slip.
It already dropped.
But don't do this.
Press admission item number 1.
Yes.
Item 1, sir.
Business for the fund. Since 2015. There is no representation on behalf of the. It appears that with the lapse of time, the case has lost its efficacy. Application stands dismissed.
Item number 2.
It may please your lordship. In this writ appeal, the appellant wants to challenge on the ground that he only worked only for 187 days.
Illegality. An order.
Money, he has got a right to be appointed when there is any
So
vacancy.
many of
He
the.
moved to the state administrative tribunal number of times. Thereafter, that case was transferred to
Absolutely.
at
Absolutely.
least his representation may be considered.
In the present.
I may be permitted to file a representation.
No. In the present intra-court appeal, an order passed by the single judge of this court, dated 6/7/2023, passed in WPC bracketed OAC number 1013
Till my lord, there are vacancies. Till there are vacancies.
2019, whereby the petitioner's writ application has been dismissed. Stop. From the, it is not in dispute that the facts are recorded in the order suffer from any error of record. Stop. Indisputably, the petitioner had worked for 187 days. It is the appellant's case that the appellant had worked for 187 days under
Respondent 2 and 3.
is
Directorate of Employment, Heads of Department,
respond number 2 and 3.
and District Employment Exchange Officer.
He had approached the state administrative tribunal by making an application giving rise to OA number 4556 bracketed 6
C.
slash bracketed C slash 2016, seeking direction for his re-engagement, as according to him, there was a vacancy line. Stop. The said original application was disposed of by the tribunal by an order dated 18/5/2017 with a direction to the opposite parties to consider the petitioner's grievance for his appointment as a PN against the vacancy which had occurred with effect from 31/1/2017. The appellant's claim was rejected.
My lord, there in 1979 Supreme Court in Beliapa case, that was appointment only for 180 days. For
The appellant's claim was rejected. Stop. The said order came to be challenged by filing the aforesaid. This was the petition.
That is,
had
originally it was original application before the state administrative tribunal,
Before
subsequently it
the
was transferred
State
to.
Administrative Tribunal, which came to be transferred to this court after abolition of the tribunal, giving rise to the aforesaid WPC bracketed OAC number 1013 of 2019. Stop. And single judge noted the admitted fact that the appellant was not in employment since 1995 and prior to his disengagement, he had rendered only 187 days of work. Stop. A plea was taken on behalf of the petitioner before the London single judge that the appellant was not claiming any regularization or appointment as on permanent basis. Rather, he claimed his appointment against a vacancy caused due to retirement of another employee. Stop. You said plea has been rejected by the London single judge by the impugned order. Stop. Next, we do not find any legal infirmity in the impugned order. The petitioner did not have any legal right to be considered for appointment against the post which had become fallen vacant in 2017. In 2017, consequent upon retirement of an employee. Stop. We find no merit in the present appeal, which is accordingly dismissed.
You would permit me, I would like to say only few words.
In this case,
In this case, if my lordship would permit, I would only say, gone are the days of Henry VIII where he can hire and fire. Once he has completed 180 days, he has the right to be considered.
all right.
Item number 3.
Item number 3, my lord, remember I took time to take instruction. I have received the instruction now. The instruction is there is no constitution of the governing body till date, number 1. And the sub-collector as president of the governing body is continuing. A proposal has been received from the college for reconstitution. So if my lord will now permit me, I will go ahead and reconstitute the governing body within a period of 1 month.
May I be permitted? So for the writ appeal concern, I don't think that is now no more survive, because my client, who is the respondent, he is retired. She won that post of principal. Now my client is retired since 31/3/24 March. So nothing remains.
You know that this is a fact. He has retired from service. However, respondent number 4 and 5 who are having tendered career against who are involved in misappropriation college fund, and there are governing body resolutions against them, and those resolutions were before the government not to approve their service against this post, ignoring that the service of respondent number 4 had been approved. That was challenged before this honorable court. That aspect has not been considered. Now, what has happened?
Respondent number 4 has retired.
No, yes, may I suggest in the chase circumstances, may I pray before lordship that now government has to reconstitute the governing body, and the government has to also approve the one in-charge principal. Then they come out of the senior most teachers of the college. So while doing so, government may opposite party 1 and 2 may kindly be directed to look into the resolutions passed against the incumbents while approving the service of those persons against the in-charge principal, and accordingly case be disposed of. I have nothing to say because that incumbent has already retired. And respondent number 5 against whom there is also allegation, he is also involved. Now he has been handed over charge by respondent number 4. In view of the circumstances, my limited prayer before Lordship that writ application may be disposed of with the direction to the government to make constitutional governing body. I am not standing on the way, but while approve the service of in-charge principal.
Let us see what order comes out. Let me try. An order dated 19/10/2023 passed by a learned single judge of this court in case of WPC number 32325 and 31479 of 2023 is under challenge in the present intra-court appeal. First off, it is apparent from the order, from the materials on record, that the dispute related to continuance of respondent number 4 as the principal in charge of which college?
Anchaliko Higher Secondary School, Talmud.
District on board.
Talmud,
Talmud.
In the district of Angul.
Angul.
It is an admitted fact that respondent number 4, after having attained the age of superannuation, retired. So stop. This intra-court appeal has thus become infructuous for all practical purposes. So stop. Learned counsel appearing on behalf of the appellant has, however, submitted that the estate ought to have constituted a governing body of the college in accordance with the rules.
Yes.
Naam de do rules ka. What is the name?
91 rules.
Odisha Education Establishment Recognition of Private Junior College Higher Secondary School Rule 1991.
Please give the name of the rule. Please give the name of the rule. This writ appeal stands disposed of, but with an observation that it is expected that the state government, that the concerned department of the state government shall look into the statutory requirements of constitution of a governing body under the rules.
Because that apart, your lordship may kindly,
Reconstitution.
that apart, your lordship may kindly direct the government, the opinion number 1 and 2 to look into the resolutions run up against the governing by the governing body against the incumbents while considering their candidature
not
for the
the prayer.
post.
Those are not
Because those
the issue.
resolutions are on record, and we are on a record before the Lord single judge. However, ignoring that part,
We see no reason why, we see no reason why after constitution of governing body in accordance with the rules, the governing body shall not proceed in accordance with law for the purpose of appointments of designation of
Principal in
principal
charge.
in charge.
designation of a qualified person as a principal in charge. So,
My lord, kindly say
happy?
reconstitution.
My lord,
My lord, kindly say reconstitution. My lord had directed constitution, it should be reconstitution.
Reconstitution. Reconstitution.
Item number 4.
My lord, item number 4, my lord, may kindly be taken up on Wednesday, because I was to file an affidavit, amendment has been made. So I'm the only filing affidavit. I will file it tomorrow.
As requested on behalf of the estate, list this matter on 1 week.
Item number 5.
Lordship, on behalf of Mr. Chan, Lordship, kindly pass over, Lordship.
As requested
Deeply obliged.
1 week.
Item number 6.
May I please, Your Lordship, but the matter is relating to grant NOC running of the nursing school is a remote place of Orissa, that Nabarangpur, district Nabarangpur. I have filed one amendment petition that is allowed. But that is only to amend the prayer portion of the petition. And consolidated page I have already filed. That may be accepted, maybe taken up any date for addition.
No, sir. What is the matter
The matter
about?
is relating, my lord.
NOC is over.
Yes. I'm challenging the order of rejection under Annexure 7.
No, that session is over.
My lord, I have complied everything, no defect there is.
All
And my
right.
lord,
Already we allow your writ application, then what will happen?
my lord, only similar order be passed, that is.
What will happen if we allow your writ application?
Only I may permitted, my lord, to file application for running of the school for the year.
Can you run this? Can you
24-25.
admit a student? So
Two
that session is over.
The 2024 to 25, my lord, next year.
You have filed
I will
for
permit it.
2024-25.
Yes, my lord, that is my prayer of amendment.
My lord, he has
I have
You
allowed.
will
he has not
you will
applied
have
for
to make a fresh application.
I may permitted to apply, my lord, because
You
that,
may permit it to apply.
my lord, I have applied for the year 2023-24. In the between 1 year already passed. So I may permitted to apply for the year 24 to 25.
One counsel appearing on behalf of the petitioner seeks permission to withdraw this application with the liberty to make a fresh application for grant of NOC for nursing course
2000 nursing course.
for the academic session 2024-25.
25.
This application stands disposed of with the liberty as sought.
My lord, 24-25 already time is over. Application.
With granted permission, I will apply.
No. Why time is over?
Yes, my lord. So from January, it has been over. Application for invitation for NOC.
Then what can be done?
So because the pending of the matter, I may permit it.
Or if the time has not lapsed. All right. If the time for making of application.
My
has
lord,
not lapsed,
time already expired.
Then
Sorry, because
you cannot
my
extend that.
application is pending before the honorable court, I may permitted to apply.
Sorry, that is not the law. That you should have applied.
My lord, because of my lord, I have challenged the order of rejection. Because I have complied everything, they have rejected my application. For that reason, Annex 7 I am challenging with all documents also. All documents. So I may
Could not have
permitted
come-
to.
Mr. Counsel, I could not have come to your chamber to advise you what you were required to do.
My lord, pending of the
It
litigation,
was your duty to advise your client properly.
I am permitted. My lord,
Sorry,
for that reason, I have amendment petition.
sorry, sir.
Item number 7.
May I please, Your Lordship. Last occasion, my lord, the government had taken time to comply the order.
Instruction that the matter has been taken to the Central Secretary of the Legal Ministry of Law. Whether it is implemented or any legal implement there. So
So
there's
when was the order passed?
Order was passed.
My lord, order was passed
Just
2022, my lord.
Jain sir, may I be permitted
4
to,
March 2022.
Jain sir, I may be permitted, my lords?
Please wait, let us see the order.
Okay, my lord.
Where is the order?
My lord, order, my contempt petition, page 18, my lord, kindly see. Page 19. Page 19, last.
What is the date of the order?
My lord, date of the order, my lord, page 11. My contempt.
Date of the order cannot be page 11, all right.
Order to the recusal.
Date of the order. 4/3/2022 is the order.
Yes, 4/3/2022. Yes, my
This
lord.
is the order.
Yes, my lord.
Which has-
Thereafter, my lord,
Thereafter,
the opposite party challenged the order before the Honorable Supreme Court, and the Supreme Court upheld the order, my lords. That is the date of Supreme Court dismissed the case, my lord, 2023.
So what is the order?
That are 4 July 2023. The Supreme Court upheld the order, my lord, sir. They've stated their affidavit, my lords, case 2 itself.
Yes, the order has not been implemented.
It's,
My lords,
Someone has joined. Yes.
may I, my lords? My lords, my name is Brigadier Ajin. My lords, I am the senior most legal officer of the Central Command, which is located at Lucknow, my lord. The legal cell of Cuttack comes within my jurisdiction, my lords. That's why I'm entering appearance on behalf of alleged contemptor number 2, my lord, the Chief of Army Staff, my lords. If I may be permitted to make submission, my lords.
Yes.
My lords, we are not justifying the delay on our part. The matter is with the government, my lords. The government has referred this matter to the Ministry of Law and Justice Centralized Agency section. I am being instructed by the my service headquarters that probably within 1 week this matter would be resolved, my lords. Kindly, I am only requesting. I am apologizing for the delay. I am apologizing for the delay, my lord.
All right. No issue. Please do it within 2 weeks. We are
My
giving
lords,
you
I will be grateful. I will be grateful for that, my lords.
Mr.
I am
Brigadier
Ajin, my lord.
Rajiv.
Ajin is A-J-E-E-N, my lords. A-J-E-N, my lords.
Brigadier Ajin has joined. Brigadier Ajin, you are heading?
I am heading Headquarters Central Command. I am called the Deputy Judge Advocate General, my lords, in Headquarters Central Command, Lucknow.
Deputy Judge Advocate General. Joined the court proceedings online. Then Deputy Solicitor General for India is also present. The court has been assured that the court's order dated 4/3/2023, violation of which is being alleged in the contempt proceeding, shall be complied with within 2 weeks.
My lords.
List this matter on 2 weeks at the top of the list. Yes.
My lords, the order is dated 2022, my lords. Probably my lords have said 23. 4/3/2022.
4/3. Thank you. 4/3.
My lords, I am greatly obliged, my lords.
Item number 8.
The order out of which the present person arises is at page 9, and the operative part is page 10. The order at paragraph 5, page 10, paragraph 5. The read petition is covered by so and so. The input was set aside and passed. Mr. Nanda prays for direction from the Tahsildar to record name of his client in Halaura so and so. It is must apply to the Tahsildar who is directed to deal with the application expenses in view of the order made. This order was made on 16/2/2023. I applied in May 2023, and these are numbered, but not yet disposed of. For that reason, I applied. A mutation case number I have provided in paragraph 5. That is to be disposed of by the Tahsildar.
I'll find out because probably because there is no time limit. I think he has not done. I'll take instruction or may call it 4 chapters. I will see that in the meantime it is disposed of. That mutation case.
4 weeks time is allowed for the estate for the contempt allowed for an AGA to seek instructions from the contemners as regards compliance of this court's order dated 16/2/2023, violation of which has been alleged in the present contempt application. Place this matter on court.
Item number 9.
Same in the second matter.
The subitem is same.
The order is different.
Item 9.
May I challenge the order, my lord, it on to page 47 is the order, my lord, of the honorable single judge, my lord. The relevant portion we challenge, my lord, is at page 54, paragraph 6.1. Page 54, paragraph 6.1, my lord. May I read it, my lord? In terms of the said order, petition also joined on 29/11/2019. Since the petitioner at no point of time assailed the order of engagement so issued under Annex 5 as submitted a joining report, the claim to get the benefit of retrospective appointment with effect from 26/9/2011 as per the considered view of this court is not entertainable. This fact is wrong, my lord. Let's turn to page 50, my lord. Paragraphs.
Is there any concept of retrospective
Yes, my
appointment?
lord. The advertisement made in 2011, my lord. I was ignored. There are 4 posts reserved for the woman candidate, my lord. I was not given. Then I challenged before the tribunal, my lord. The tribunal quashed the order and directed, that is at page 19, my lord, to give me appointment, my lord. The order was passed on 2016, my lord, to give me appointment. They did not give me appointment, my lord. They filed writ petition before this honorable court. This honorable court disposed of the petition in 2018. They filed review petition. Review petition was dismissed. After that, my lord, they gave me appointment prospective, my lord. I claimed, at least from the date of the tribunal's order or from the date the other candidates from the same advertisement were appointment, my lord, appointed.
So whether any person junior to you was appointed in the merit list,
Well,
below in the merit list was appointed.
well, there is no, hence 4 posts reserved for women candidate, my lord.
All right,
Against
we
the
have
women.
quota question.
Yes,
Whether any person of lower merit was appointed.
any person, my lord, there is no junior, my lord, because the quota reserved for women candidate, that was.
We are again putting the same question. This is third time that whether any person having lower merit was appointed.
Yes, my lord.
Lower merit.
Lower merit, my lord.
Was appointed.
Yes, my lord.
Is there any finding?
Yes, ma'am. That was finding before the tribunal. Finding of the tribunal, madam. Tribunal order.
To us.
Yes, ma'am. That, my lord, page 13, Annex 1, my lord.
Yes.
The tribunal order.
Where is the finding?
My lord.
Where is the finding?
Finding, my lord, you'll see, turn to page 16, my lord.
Read it.
Out of 45 numbers of classical teachers for Sundargarh Circle, as per advertisement number 5/3/2011, the number of posts reserved for SCBC and SCBC women are 9 and 3 respectively, in accordance with 80-point roster filled up from 57 to 58 and 1 to 21, as per the provisions of the Odisha Reservation and Vacancy of Post in Service Act 1975. This is the observation of the counter, my lord. Then I will sit on the court's observation, my lord. Court's findings, my lord. Page 17, paragraph 5, my lord. Both sides have advanced their argument in light of their respective pleadings. In this case, Learned Standing Counsel for SME had been directed to produce the acts and rules regarding reservation and roster point register, and subsequently by order dated 3/2/2016, specific order has been passed that if the roster point register is not produced, then adverse inference will be drawn. But in spite of that, roster point register has not been produced. In the advertisement dated 5/3/2011, it is stipulated that the provision of Odisha reservation of vacancies in post.
That observation is for the reason that the reservation policy was not properly implemented.
Yes, madam.
All right. So whether in that group, in that class of the reserve category, someone was appointed having lower merit. This is one.
Yes, ma'am.
And the other thing is that in any case, retrospective appointment cannot be given. Retrospective, your seniority can be maintained.
Yes, ma'am.
You can be. Seniority cannot be maintained. Therefore, we were asking.
That, my lord, at least the tribunal directed in 2016 to give me appointment within 2 months, my lord. Within 2 months, my lord. They have not, they appointed me in 2019, my lord.
Yeah, yeah.
They appointed me in 2019.
Show us any decision. Is there any decision that appointment should be given retrospectively?
Yes, my
Is
lord.
there any decision?
Yes, I will give, my lord.
There is no decision.
Yes, my lord, there is.
Huh?
I will give the decision.
You will give the decision.
I will give the decision.
Yeah. You will change my whole concept.
Tomorrow or after tomorrow, I will give you.
All right, we would like to see. But if not, then how much?
I think I will be.
Your client will not pay. If tomorrow we do not accept your contention, then we will not impose cost on your client.
I will try my best, my lord.
You will have to do something.
I think I will.
If we don't accept your contention, then you will have to do something for the members of the bar. Ready? All right.
Then.
No, not more than tomorrow. As requested on behalf of the, but come ready.
Yes, my lord.
Not on the case law. Come prepared.
On case law, my lord.
Cash.
On case law.
For the bar.
For the members of the bar. You'll have to contribute to the association.
I will.
If you succeed, then it's all right. If you fail, then you'll have to do that. Option is, choice is yours. All right, as requested. Don't worry. As requested on behalf of the appellant, list this matter on tomorrow.
Tomorrow, my lord.
Item number 10.
Well, day after tomorrow. Day after tomorrow.
No. Sorry, it is because of our poor memory we don't want to.
No, my lord. Yes.
Item 10.
Last occasion, sir, I properly scrutinized against Article 227. Appeal would not last. So I prefer to admit it to withdraw.
Then
It's a liberty. Certified copy may be returned.
Appellant seeks permission to withdraw this application, in realizing the fact that this intra-court appeal against an order passed by London single judge in exercise of power under Article 227 of the Constitution not containable. This writ appeal is accordingly dismissed as withdrawn.
Item number 11.
Item number 11, my lords, I pray may kindly be taken up next week, my lords. My lords, may kindly be taken up next week.
Right, sir?
Because the conducting counsel is not well.
Not well, but you are conducting counsel, it appears. Hmm?
You are in caveat. You are in caveat. For opposite party number.
Opposite party number.
Is there any merit?
Madam?
Is there any merit in the appeal?
No, man. We have no local standard to file this appeal.
All right, as requested on behalf of the appellant, let this matter on. Your senior has to argue
My lords.
on 1 week.
7.
Item number 12.
Madam, 1 week after.
1 week.
But in this matter, my lord, I have just filed an amendment petition formally that has come on record. If that is allowed, I am also ready with a consolidated copy.
8420. 8494. It was there is no 94 or 84.
The question posed to me was only that whether an writ appeal would lie against an interim order. I would place before our lordship. But the facts in brief are, I have filed an application for extension of time for the purpose of rearing fish, which I admittedly had cultivated, and the Honorable Court was pleased to grant time. Grant 2 weeks time to do that. And during that period when I went there to harvest, there was disturbances for which FIR was lodged, so much of complications were there, the criminal cases were initiated, and ultimately I could not harvest the fish which I was permitted to. Then I came up to this Honorable Court along with an application for grant of further time so that I can be able to get the benefit of the direction given by this Honorable Court. By order dated 22 to...
No, which is the order under challenge?
Yes, that order is at page Annexer 5. At page, it starts at page 42. 44 is the order. Paragraph 2, keeping in view the limited scope granted in favor of opposite parties 6 and 7 in the order dated 7/2/2024, this court refrains from passing any further direction either to extend police help or to modify the said order. Let us, I may be permitted to place that order dated 7/2/2024 at Annexer 3. Page 30.
But your matter is listed on 22nd April. Why should we take up?
Well, 22nd?
22nd April, your matter is fixed before the learned single judge.
That is one matter. That case can be heard, Millet. I have nothing to do on the merits of the case. Merits of the case, I will argue there. But the problem is, because of I had cultivated the fish, and now because of this hot summer and so many things, the fish will die. Therefore, I filed an application that I may be permitted to harvest that. That was permitted. And thereafter, because of the intervening circumstances, I could not take advantage of the order. And then again, I came up before the Honorable Court saying that these are the difficulties.
No, but whatever submission you are making, you can make on 22nd.
22nd, well, this matter is closed. So far as my permission for me to rear the fish is over already. That cannot be again reopened. Only on merits whether the petitioner, I am for the opposite parties. Whether the
What the division bench can do today, even if all submissions are accepted, that can be done by learned single judge on 22nd.
Well, this matter is no more available to be considered on that day because during the interim period, I have requested the Honorable Court that I may be permitted to rear the fish, which is there already, which admittedly I have cultivated them. So that permission was granted.
15 days time was granted.
15 days time was given to me. During that period, because of the disturbances, I could not. Police case and other things have come.
That cannot be taken up in the present proceeding.
Your Lordship may suggest one thing, Madam. Your Lordship may say that this petition be reconsidered by the Honorable Single Judge at the time of final hearing. I have no difficulty.
There is no question of reconsideration. For reconsideration, we will have to set aside the order. And for setting aside the order, there must be compelling circumstances.
That's what I am only placing that. What I am saying is because since your Lordships have suggested that since the matter is finally going to be decided soon, there is no need of again entertaining this. Therefore, I am making a submission because this matter cannot be reopened there again unless your Lordship permit me to raise this question and again, once again, the Honorable Court will consider.
You will have to convince his Lordship whether any interim order can be passed or not passed, should be passed. Very difficult, sir.
But the entire purpose of my filing the petition is frustrated because
it happens.
It It happens, but
It happens finally if your matter is decided on 22nd or 23rd, and then you come, we will see what order can be passed, what can be done.
well, ultimately, what the matter is, I have been granted lease. And I took over possession. Thereafter, the petitioner has challenged, saying that how the lease could be granted without auction. That is how the matter is pending. If the auction is held, all right, whoever will be the successful person will take it. Otherwise, if the order is sustained, I will keep it. But the question is, in the meantime, the fish which are already there, which I have also will die.
See, your concern is about the life of the fish. The question is the legal right. Your legal right vis-a-vis the legal right of the other person. That has to be determined.
I'm greatly obliged to my lord, but the question is, I assert my right by saying that apart from the merits of the case, whether the lease
by whom?
My lord,
Writ petition has been filed by whom?
by the opposite party number.
By the opposite party.
Opposite party. Present respondent. Who?
Therefore,
Respondent number one, Mr. Bog is appearing for them.
and if he withdraws the writ petition, then what will happen?
He is fighting tooth and nail and quarreling on the spot and
We don't know.
trying to.
We can't assume what would happen on that
correct.
day.
That is
On
correct,
the
my
date
lord.
fixed.
But all the same, from the conduct it shows how they are fighting for this.
May I come in this matter? In the pending writ application, my lord, we have received the Paravis comment. This will not be maintainable because our stand is that the auction has not been done. It will be done prior to the date fixed. And so there's a question of having lease in either of the favor doesn't right. It will be done before the counter. Yes, we have received the Paravis comments. We'll file the counter there, my lord.
Well, absolutely, I have no quarrel over the position. What will happen in the
We are
petition on which it will be there.
Mr. Rao,
Well,
We are in intra-court appeal.
yes. Your lordships wanted me to examine if the appeal would lie at all. I have got some other.
That has become academic, but still, just give us the list, we will do for our.
No, I will give it. I will give a memo with the notes and other things. That
This
according to
we
my humble
understand.
submission, it is maintainable. But
No, we don't say that it is not maintainable. In cases where that amounts to granting the final relief, yes. Appeal can be maintainable.
Because the Patna High Court's letters patent is being followed by Orissa.
Yes.
And Patna High Court's letters patent clause only says against the judgment.
Mr. Rao, a day may come when the bench may request you as to why we should continue with this letters patent. Whether the rules should be amended or not. Why this letters patent? Letters patent is over. This is not this for this.
That's right.
We
I
just
understand.
gave you an indication that
In a way, there is already a restriction by introducing section 100 capital A in the CPC. Appeal is maintainable, but we are prevented from filing it. That is how interpretations have come up. In fact, full bench judgment of this honorable court is also there on the point. A lot of deliberations were there. But
no, we can maintain writ appeals. Writ appeals we can maintain, but while this letters patent is there
that's
any,
right.
is there any
Your
requirement?
lordship is also right. Why so much of complications? Straight away put a rule that appeal is
Put a
maintainable.
rule that rule is maintainable. It is appeal is
That's right.
maintainable. Why
That is right.
LPA?
After this uniform civil code comes, all these things may be.
Even without the uniform civil code.
That is right.
Even without uniform civil code. In fact, this is just a hint to you so that all the senior advocates may consider whether,
Your lordships
whether
are
there
right.
is any requirement. In fact, speaking for myself, sometimes I find it very difficult to read that.
That language is.
The letters patent.
That is correct.
All right.
Here my limited grievance and
All right.
your lordship may grant at least 1 week time so that I can have my,
In the present intra-court appeal, the appellant has put to challenge an interim order dated 22/2/2024, passed in WPC number 5146 of 2023. From the said order itself, it appears that the matter is fixed before the learned single judge on 22/4/2024. Stop. The order reads thus. Stop. In the facts and circumstances, after having heard learned senior counsel appearing on behalf of the appellant, former state, and the private respondent, we are not inclined to interfere with the order, with the interim order, considering the nature of order which has been passed, particularly when the main matter is coming up for hearing on 22/4/2024. So this appeal is accordingly dismissed, but with an observation that we have not gone into the merits of the case.
may I seek indulgence of one more sentence that I may renew the prayer before the Honorable Single Judge.
You can do.
But that's only for an extension.
That goes without saying. We should not make such observations while reading.
I understand that, madam. That's why I said indulgence of one more sentence, that it is open to the petitioner to renew the prayer. Because once your lordships have dismissed this, that order is confirmed. That order is confirmed. Legally, we will face the hurdle to move it once again.
Only because of this. There's no question of
Quite
confirmation.
understand that.
Only we have not gone into the merit. That's
Quite
what we have
correct.
mentioned.
Again, that will.
Huh? Otherwise, you may withdraw. Whatever you.
That's right. Your lords may permit.
Senior counsel, after some argument, seeks permission to withdraw this appeal, to which learned so-and-so, state counsel, and learned counsel representing the private respondent do not have any objection. This writ appeal stands dismissed as withdrawn. Stop. We make it clear that we have not entered into the merits of the case. But please work out on that also. Even the young members of the bar should be encouraged to examine what is the compulsion for the court to continue with that.
I quite understand.
All right. Because we are in the process of revamping the entire High Court rules.
That's then this will be of some requirement. May I have one more second from your lordship?
In this case?
Yes, in this case. Your lordships have said that I have been permitted to withdraw with the liberty to move afresh before the legislature. That's in my mouth, your lordship put it.
Only with the liberty to renew his prayer for a restoration of earlier interim order maintaining status quo. So, we make no observation over such prayer. This application is dismissed.
Item number 13.
May I please notes? Notes this writ appeal is direct. This writ appeal is preferred against impugned order dated 1st March 2024. passed by my lord, single judge, Honorable single judge in WPC number 12356 of 2018, which was a final disposal matter, on completion of pleadings after filing counter and rejoinder and written note of submission by respective parties.
What happened?
My lord, this writ appeal is preferred against impugned order dated 1st March 2024.
Annexure?
My lord,
Annexure.
Annexure 8, my lord, at page 72.
Yes.
Passed by my lord, Honorable single judge in WPC number 12356 of 2018, which was a final disposal matter on completion of pleadings after filing counter, rejoinder, and written note of submission by respective parties. My lord, may be permitted to place in order to justify the grounds taken in this writ appeal, may be permitted to place the writ application.
No, what is the point? On what ground?
My only point is that without touching the merits of the writ application, my lord of the single judge dispose of the writ.
If there is no merit in the writ application, then that cannot be touched.
No, my lord, that is my point, my lord. My lord, because I may be permitted to place the writ application, my lord.
Which we do. Please don't read the entire writ application.
No, ma'am.
What was your grievance?
The observation is that is.
What was your grievance before the
My
writ
grievance
court?
was that after rendering lengthy unblemished service for more than 20 years.
Regular?
Yes, my lord. The
Where?
committee of management, that is our.
Where?
My lord,
In which department?
that is respondent number 4 and 5.
Who is respondent number 4?
That is Aska Central Cooperative Bank.
Huh?
Aska Central Cooperative Bank. Aska Central Cooperative Bank.
Aska.
Yes, my lord.
ASKA.
My lord.
Yes.
My lord, during course of unblemished service for more than 20 years, the committee of management took a policy decision dated 18/1/2018 for the giving promotion to these appellants. And accordingly, that policy decision was given effect under Annexure 1 series, my lord. That is page 20.
To which post?
My lord, banking assistants.
Banking assistant.
Yes, my lord.
From
the post of cadre secretaries. Cadre secretaries.
Cadre secretary.
Yes, my lord.
The decision was taken.
Yes, my lord.
Then what happened?
My lord, accordingly, the appellants were given promotion under Annexure 1 series at page 22.
Yes.
My lord, that is may be permitted to place.
Yes.
In pursuance of
Then what happened?
Thereafter, that our promotion order was brought under challenge in the dispute case number 138 of 2018 before the respondent number 2.
Who is respondent number 2?
That is Registrar Cooperative Societies, Odisha.
Yes.
And we are giving notice, and we entered appearance in that as per the notice that dated 8/3/2018 under Annexure 2. We entered appearance in that dispute case, and a date was fixed to dated 2nd June 2018 under Annexure 3.
Which date was fixed?
2nd June 2018.
Then what happened?
And the date was posted to 21st July 2018 for filing WS, objection if any, and hearing on the
What happened finally?
Yes. Well, when the dispute was pending adjudication before the respondent number 2, we were heavily shocked and received of reversion order dated 9/7/2018 under Annexure Annexure 4 series, my lord, that dated 9/7/2018.
So you were reverted?
Yes.
Then,
my lord, that is, those reversion order was only basing upon a direction given by the respondent number 2, basing upon an inquiry dated 29/6/2018.
yes.
And that inquiry report, we are admittedly not parties to that inquiry report. And that inquiry report has given effect in accordance to the satisfaction of the General Secretary of the Employees Union. And that resolution, that inquiry report is finding place at page 66, my lord. May I please, my lord?
So this is your simple case.
Yes.
That you were promoted to the post of banking assistant.
Yes, madam.
Which was challenged before the registrar.
Yes, madam.
During the pendency of that challenge,
Madam.
your promotion has been withdrawn.
As per the direction of the
Your promotion has been withdrawn one. That is on the basis of the registrar 2. There was no direction issued by the registrar to terminate your or withdraw your promotion. Was there any direction?
Yes, my lord. That is the crux of the matter, madam. That is inquiry report dated 29/6/2018 under annexure F/3, which was filed.
Where is the order of the registrar?
Yes, that is page 65, my lord. Page 65. To the Chief Executive Officer, ASCA Central Cooperative Bank Ltd, ASCA, sub compliance on the inquiry report sought for. Sir, in enclosing here with a copy of the inquiry report dated 29/6/2018 of the RCS Odisha, you are instructed to furnish the compliance on the same within 3 weeks positively for kind perusal of the RCS.
So
then next page 66. Page 66 is very relevant. The inquiry report of the registrar. The name of the petitioner, serial number 5, General Secretary, Primary Agricultural Cooperative Society, Employees Sangha. Then para 7, process of inquiry. On receipt of the allegation petition from General Secretary, PAX Employees Sangha, DRCS Barampur Division was asked to conduct an inquiry on the matter and submit a report. On receipt of the report of the DRCS Barampur Division, RCS Odisha decided to conduct an inquiry on 30/4/2018, and accordingly notice was issued served to the Secretary, ASCA Central Cooperative Bank, DRCS Barampur, and General Secretary, PAX Employees Sangha by this letter dated so and so, dated 10th April 2018, to remain present for the inquiry. So admittedly, we are not parties to that inquiry, madam. And this inquiry report has been given effect for the purpose of passing resolution dated 5/7/2018 of the committee.
This inquiry report is submitted by registered cooperative societies.
Madam.
Page 69.
Yes, madam.
No, this is not very difficult. This is Registrar Cooperative Society.
Yes, madam.
Is it an inquiry report or order?
Yes.
Madam.
Yes.
Is it an order? No. Where is the inquiry report?
That is the inquiry report, madam. Heading page 66. Page 66. Heading is the inquiry report.
This inquiry report is prepared on the basis of petition filed by
The General Secretary.
So in this, you are not heard.
No, madam.
What is the reasoning assigned by the learned single judge?
My lord, there is no finding on this aspect, madam.
So he has proceeded on the basis of amendment.
Yes, madam. That which is not subject matter in the
Staff amendment,
Yes,
staff
madam.
rules.
My lords.
That has no way connected.
Yes.
But inquiry report, some indication is there with regard to 2011 rules.
Madam.
Inquiry report.
Yes.
indicated with regard to this rules 2011 inquiry report.
Inquiry report. No, in that inquiry report, that was not, regarding amendment is concerned, that was not the subject matter. That cannot have any retrospective effect.
Let us see the order of your reversion.
Yes, that is at page 34. That's page starts from page 34. In pursuance of letter number so and so dated 29/6/2018 of the Registrar Cooperative Societies Odisha Bhubaneswar and the resolution number 5B of the Managing Committee dated 5/7/2018, the office order number so and so dated 7/1/2018 issued to Sri P.K. Pradhan appointing him banking assistant is hereby reversed.
ID Act will have no application.
My lord?
ID Act?
No, ID Act is not applicable.
Yes, how can you do this?
And that resolution.
Registrar was in session appeal.
No, madam. He was deciding a dispute case at the instance of respondent number 6 to 13.
Some of them had challenged, and in the meanwhile. Notice. How many persons?
My lords, the private respondents are also there.
The speed post.
1 to 13, man.
Requisites 1 week.
Yes, ma'am.
State.
I'll receive notice for 1, 2, 3.
1, 2, 3.
1, 2, 3.
So accept notice for one.
So for rest of the one set of process.
My lord.
Street.
Yes, my lord.
Speed post. Non-appearing respondents. Speed post. Registered.
My lord, I have also interim application.
We take notice. IA.
My lord, I have also interim application.
IA?
Yes, my lord.
All right, he is taking notice. So notice. IA and
status quo may be granted because now, curiously now, they are going to fill up the post of.
They did come. No, file notices first.
All right.
Item 14.
14, one passover. One passover. One passover because I'm.
14.
Yes, ma'am. One passover.
One passover.
Then I'm taking up. Yes.
14.
Yes, 14.
Why one passover?
Because in this. Because
All right.
I'm placing the matter.
All right. Well,
Yes.
we will take up your case after some time.
Yes.
Item number 15.
Whenever you feel free, comfortable.
Just within 15 minutes.
May I please, my lord? My lord, in this case, the praying petitioner had preferred an application writ application before this honorable court, challenging the illegal appointment of the opposite party number 5 in violation of the rules set by the Department of Higher Education itself in appointing the principals to the degree colleges, degree non-government aided colleges, Your Lordship. And this petition was filed by the petitioner, on which the Honorable Single Judge was pleased to issue notice, and the opposite parties, both the government side and the private opposite parties, they filed counter, and the petitioner filed the rejoinder. But in the meantime, while the case was being taken up, on the first instance, this Honorable Single Judge was pleased to grant a stay operation on the order, on that particular appointment order, and had directed the opposite parties in the subsequent day to put on an interim arrangement which will exclude the petitioner and the opposite party number 5 till the disposal of the case, Your Lordship. Your Lordship, during 4 or 5 hearings.
This is the order under challenge, Annexure 7.
My Lord. My Lord.
This is an interim order.
No, Your Lordship, this is a final order. The case has been disposed of by that order. My Lord, my simple humble submission for Your Lordship's kind consideration is that the points of law has not been adjudicated upon. The facts of the case have not been gone through. The interim order was passed to put on interim arrangement till the disposal of the case. Now, after resisting that order for some time, finally, when they complied by putting an interim arrangement in the form of asking the principal of the nearby college to officiate as an interim caretaker principal, on that note, the Honorable Single Judge has disposed of the case, and thereby it meets no ends of justice because it perpetuates a condition of anomy, which has given the opposite party, government opposite parties, the right to be arbitrary in appointing principals because no rule is being applicable to them, and they violate their own made rules with impunity. That's why this order actually doesn't meet any ends of justice and doesn't adjudicate upon the prayer of the petitioner. And in perpetuating an uncertainty, the order has been passed.
Speaking for myself, I have not been able to understand what is the controversy.
Well, the controversy is that the opposite party number 5, who is a +2 college, junior college appointee, by rule cannot be appointed as a principal of a degree college, which they had committed, the mistake they had committed. They had appointed opposite party number 5, who is a junior college appointee, and according to their made rule, shouldn't have been appointed as a principal of the degree college. They made that appointment. Challenging that, I came filing a writ petition before this honorable court. This honorable court was pleased to issue notice on that question, and the opposite parties filed their counters. And in that counter, they took untenable points which were rebutted by the petitioner through the rejoinder. Both the opposite parties, government opposite parties and the private opposite parties. And when the matter was slotted for final disposal, in the meantime, my lords, on the first day, the order was stayed by the Honorable Single Judge, and a direction was issued to put on an interim arrangement till the disposal of the case. And in that interim arrangement, it was directed that neither the petitioner nor the opposite party will be involved. Now, they put in place a person who is 4th in the rank. So there were dissentments both from the petitioner side and also from the opposite party 5 side. Therefore, the Honorable Single Judge modified the order and directed them to place somebody from outside the institution till as a caretaker principal till the disposal of the case. And that order was registered for some time, but finally they complied with that order by appointing the principal of the nearby college to additionally take charge of this college. Now, when that submission was made before the Honorable Single Judge, on that observation, the Honorable Single Judge disposed of the case by perpetuating that uncertain condition without adjudicating on the point of law that they have violated their own made.
There was no question of deciding those matters. Those matters had become academic.
No, my lord, my prayer was that they have violated the rule in appointing the principal, and the learned judge.
So the present arrangement is an interim arrangement.
That is the case. The interim arrangement is not meeting any ends of justice because it perpetuates a kind of anomaly.
No, the present arrangement is an interim arrangement.
No, my lord, that has been made permanent because the case has been disposed of.
Mr. Counsel. clarify page 75,
My lord,
interim order
my lord.
Ah.
75, my lord,
75, para 4.
my lord,
Considering the grounds taken. this
my lord.
court
Is not inclined to vacate the interim order. That interim order was granting.
Continue.
My lord. However, taking into account the fact that regular principal of the college is retiring today, that is on 30th 11 2023. This court, considering the instruction provided by the department, directs opposite party number 1 to make an interim arrangement for smooth running of the college in question. However, it is observed that neither the petitioner nor opposite party number 5 shall be allowed to function as principal in charge of the college during pendency of the present writ petition, and prior to framing of the common cadre as directed by this court in its order 11-5 in a different case.
There was,
Your
a
Lordship,
direction, there was a direction,
Mine.
earlier direction in writ court. So unless that is put in place, they.
my lord, this direction was still the disposal of the case. Now, after they put in that,
Thereafter also, you see Premlata Raut.
my lord,
You have not submitted that.
my lord, no.
So Avijit Bose is continuing.
My lord, he is the principal of the nearby college. He is additionally continuing.
He is qualified.
He is qualified, but he is not the regular principal of this. The
He
question
may
is,
not be regular.
no, that is what is the point is that I had preferred the writ petition that I have
Point we
been,
will resolve.
I have been with
We will resolve the point.
my lord.
So, why this Premlata Raut is not being implemented?
Premlata Raut case is a different case. There, this honorable
No,
court
no.
has.
Premlata Raut requires you to frame common cadre.
Yes, that's a judgment, my lord. That direction has been issued to prepare a common cadre. So
Yes.
that is under process. That will be final.
When it is under process.
After that, because that was challenged in writ appeal, subsequently after confirmation of that.
When was the order passed in Premlata?
Raut case, my lord.
See, this is how the state generates
Yes, my
litigation.
yes, my lord. That is the problem for which that the post of principal and
This appeal does not have any merit,
yes, my lord.
but
Because
we will take up this appeal after 2 weeks. In the meanwhile,
in the meantime, I'll take instruction
Yes.
what has happened to
Yes,
that.
this is not done.
My lord, all the problems will be
So
solved.
many cases are coming up.
You have
Many
the
cases are there.
Case of Premlata Raut.
The entire dispute,
You have.
entire dispute that principal in charge.
Yes, my lord, but this question is not related to Premlata in the sense, in this case, the question is that whether somebody appointed initially in class 2 college or junior college can be appointed as the principal of.
Cannot be appointed.
Cannot be appointed.
There is this question does not require any answer.
It doesn't require an answer.
Because the answer is patent according to the rule.
My lord, that is what
All
they
right.
are saying.
So even the interim arrangement has been made
My lord,
because the cadre has not been
Common cadre.
common cadre has not been prepared.
my lord. Well, that's what is my humble submission. Even if that cadre is prepared, this rule cannot be overtaken. So that is why.
Sir, counsel, we don't have to observe on that.
That's it. I'm not
We have
for that.
an order before this court. We have to deal with this order. We will see what can be done. This litigation should not come.
My lord.
Let this matter on 2 weeks. So let the state of Odisha let who will file the affidavit?
Government, higher education, government.
Let the Department of
Higher
let
education.
an affidavit be filed by the Secretary Department of
Higher
Higher Education as regards the stage of creation of common cadre, framing of common cadre in the light of this court's decision in case of Premlata Raut versus State of Odisha and others. Do you have the details of that case?
I think I had them. It is not 20.
Decided
And that is also writ appeal is confirmed.
Yes.
No.
You challenged in writ appeal.
Perhaps that was challenged before this
You challenged.
state. That has been confirmed. And I will take instruction, file that. What is the
Don't
status of-
only take instructions.
Well, I'll
You
file an
can tell
affidavit.
them.
And I
that-
file an affidavit to that extent also.
You file an affidavit and you can tell the department
Well,
that because of that, so many cases are being filed.
yes, Malad.
So that is overburdening the court.
Yes.
All right.
That should be settled at particular level, Malad.
So they should not compel us to create some burden upon them.
Well,
That can also be done.
Okay.
Yes.
Item 14.
Weeks.
May I please notes? What's this? The appellant is a conscious senior citizen and he has been a victim of a proceeding adopted by the respondent number 2 and 4. In
You
a
are challenging
statutory
annexure
proceeding,
3.
my lord.
You are challenging annexure 3.
Yes, my lord. My lord, wherein mostly, my lord, single judge, honorable single judge relied upon the submission of the State Council at page 52, my lord. 4.1. Mr. Misler and Leonard ASG submits that earlier the petitioner had moved the court in WPC number 2433 of 2024, which was disposed of on 15th February 2024. He therefore submits that the petitioner is in a habit of moving this court and again in view of the fact that the dispute case is not ready for final disposal. The prayer made in writ petition cannot be granted. My lord, I humbly beg to submit, my lord, the dispute in question is of the year 2004.
So dispute has not been decided.
No, my lord. My lord, earlier also I moved this honorable court in earlier writ application number.
Who is for the estate?
My lord, I am for the state, your lordship. May kindly see para 4. Just before the para he placed. Mr. Misra Leonard ASC vehemently objects to the above submission. It is his submission that the order of this court was passed on 15th February 24 and 2nd March 24. The petitioner filed an application under Annexure 3 with a prayer to summon one Badhu Murmu, the branch manager of the plaintiff, for his examination on oath requiring production of deed of agreement concerning the loan in question. So he has applied for examination of a witness, and that is why the next sentence, this honorable single judge has said the matter is pending and not ready for hearing. It is he, the petitioner, who has summoned one witness.
He should not have filed that petition.
My lord?
He should not have filed that
No,
petition.
he should have filed. That is why, that is the reason for which the court has said.
Either he should have filed or he should not have filed. In either case, you were required to take a decision. When the matter is pending,
It is a fact that it is a year-old matter. The tribunal should have taken urgent steps for disposal of the same. But this is the reason for which the honorable single judge has said that the matter is not ready for
Maybe
hearing.
we are not interfering with the order, but we are not disposing of the appeal. All right.
Yes.
Got the hint?
I will ask the concerned court to.
Yes. Well, we are just adjourning it for 4 weeks. List this appeal on 4 weeks for the estate to inform this court as regards the stage of dispute case number
172 of 2004.
Dispute case number 172 of 2004.
Please.
Which is pending before learned additional registrar cooperative society.
No, my lord. Additional registered cooperative society scheme and legal.
This is what we are learned.
Respondent number 2.
Registrar
Of cooperative societies, bracket, scheme and legal.
Yes, sir.
Scheme and legal.
Office of Registrar of
Yes,
Cooperative Societies,
my lords,
Odisha.
my lords.
Opposite party number 2.
Yes.
Bracketed opposite party number 2. Ask him.
Yes, I will.
national sports person, and this is a writ appeal which is arising out of WPC 7280 by 23, disposed on 13/3/2024, and arising out
Which
of
annexure? Which annexure? Why don't you join legal profession?
Sir, I am a legal student,
You
but I have
argue so well. You can.
Sir, I am a LLB student, but I don't have any license yet.
You can apply.
Sir, my profession is I'm a sociology topper, aspirant of professor.
That we know. That we know, but it's a matter of interest.
Sir,
You're
I
taking
don't-
more interest in law.
Sir, I don't have any standard to speak in front of you people because you are the learned people, and I am a petitioner in person. In fact, I don't have any.
This observation is coming from the bench. Therefore, you may realize that you have potential, you can join. Instead of
But sir, this is the fighting. This is not the question of my
all right,
profession.
no problem. Let us come to the order.
Sir, can I say something? Sir, as
No, let us come to the order. You cannot say something. We will have to see the order. Where is the order?
sir, this order is annexed 6, annexed 6, page number 72. Sir, entire order is in my favor. Last order, it is saying that 3 posts are for reserve post. That's why we cannot, and it's filled up. It is for the reserve people. I am a sports person. I am coming into the reserve category as well. And the illegality and irregularities happened. That is why I have some identical case law. Can I submit? With your
No, let us understand first. What is your case about?
Sir, I am I have applied for the post of assistant professor university, advertisement number 8 by OPSC, conducted by OPSC 2021. I have cleared as a number 1 as per the API score from screening to document verification to interview. As per the API score, I am having the highest score as per the UGC guideline 2018. And I have also submitted that there is a calculation for API, it is as per the provision, overall selection will be made on the basis of the API score, means academic performance indicator, and interview is for only formality for the presentation. But entire order is in my favor. It is mentioned that because out of 15, there are 12 posts filled up, 3 posts are vacant, and Honorable High Court has reserved 1 post for me for 1 year, not to fill up. It is also annexed here in the, sir, kindly see. Page number 93. That page number 90. The interim measure, it is directed that 1 post of the assistant professor sociology pursuant to advertisement number annexure 1 shall not be filled up if the same has not been filled up in the meantime. And that is been reserved for 1 year. And there are people.
No, you are claiming reservation on the ground that you are a sports person.
Sir, I am a meritorious sports person. Merit means
We understand that. The moment you say that you are meritorious, means you are meritorious
both in
for being
education.
selected as assistant professor otherwise, and sports person, against that you should have been.
Sir, sports is my additional qualification.
So we can forget that.
No, sir, because in the interim, the order which they have given higher education, that there is no provision for sports
Madam,
person.
Please allow us to understand.
Okay, sir.
In the advertisement, there was no reservation for a sports person.
That has been challenged. That has been challenged in the.
All right. That was challenged after the selection process or before the selection?
After selection process.
So after selection process, you cannot challenge that. So therefore, let us stop that. On the ground of sports person, you cannot have any claim because you participated in the process of selection, and after becoming unsuccessful, you are challenging the advertisement on that ground. So you cannot argue that. Now let us come on the merit.
Okay, sir.
Forget the sports part.
All right. Then merit also from the screening, there is a process like screening. There are number of people applied for the same post, and there is a category API score, academic performance indicator. Suppose I am a PhD holder, I will score.
We can understand API score, yes.
API score. As per the API score, I am having the highest score.
How do you know?
Sir, calculation. I have
That
annexed.
is your calculation. What is the calculation of
Sir,
OPSC?
that is why the selection list also they have shortlisted me as a shortlisted for the document verification, and from document
What is your API score according to OPSC?
Sir, OPS, sir, as per the API score means it's open, when it's a transparent, anyone can calculate, because degree cannot be changed. PhD, MPhil, ICSR.
Ma'am, please answer our question. What is your API score according to OPSC?
Sir, highest, it is mentioned in the also argument also, it is mentioned that from screening to document verification, from document verification to interview. The same also has been shortlisted for the professor
Your
also.
OPI score is 50, 51, 52, 56, 56, 58. What is your?
My API score is 100 out of 197, and I am getting the national international award. That is why 5 more out of 105, 102 was my API score.
So that is the assessment of OPSC also.
Yes, sir.
OPSC.
So that is why I reached the interview in 1:5 ratio.
You reach there.
Sir, can I have a glass of water? I'm feeling very suffocated.
You can come tomorrow. Come tomorrow.
No, sir, I can.
Come tomorrow. Come.
Sir, one point I will, sir, honorable.
We will give you time.
Sir, one, please listen one grievance. Sir, actually, Honorable High Court has listened thoroughly from my counsel. He has given the direction that as per the provision of Odisha Civil Service Act, she should get one post. And then I had taken my order and along with all the representation, and he threw my higher education secretary threw all the order and insulted me, saying that is it a vegetable market? Why you are coming here? This is the kind of insult. So as per the Article 21, no one can insult. I may not get job, that is a different issue, but no one can insult me. So being a meritorious sports person in the administrative office, how he
We
can
have
insult?
limited role to play.
So that
here we are deciding a case which is against an order passed by a learned single judge.
Sir,
we have to see whether the order is incorrect or not. That is the limited jurisdiction.
the entire order.
Please come tomorrow. You want to have water? Go, pani pilwa do. Come tomorrow. Please come tomorrow. We will see.
Sir, what?
You are not in a position to argue today. Come tomorrow. Come with your written notes of argument. We will take that and we will decide your case. All right.
Sir, can I show you this?
Please give it. Have water. Give your written notes of argument, we will decide. You are not required to. Everything you have mentioned in your written notes of argument?
I will submit. I will submit written note.
All right. When?
Tomorrow.
Tomorrow you do it.
And sir, I have two covered matter. So can I?
Yes. Whatever you want, you give
Sir,
it.
can I give it right now?
Tomorrow.
Item number 17.
17 kindly may be taken on next week, ma'am.
The petitioner in person to submit written notes of argument.
Sir, thank you, Oblige.
17 kindly may be taken on next week, madam. Next week, madam.
Next week.
Madam.
Why?
Mr. Das is in another court, madam. Arguing counsel, Mr. Das is in
Requested on
another.
behalf of the. Which item is this?
17.
On behalf of the petitioner, this matter on 1 week.
Item 18.
Item 18 also next week. I'm not well.
As requested.
Can it be on 24? 24.
Yes.
Item 19.
My lord, I'm assuming this section 2C, subsection C of the OLR Amendment Act, page 29. So far
You
as
are
a quantum of compensation is concerned. So in the 1967 Act, it was 800 rupees per standard acre, which is according to the Indian Stamp Act and Odisha Stamp rules, my lord. So presently, we are losing our valuable land, my lord, and it is being to be settled in favor of the subtenant and under. But what is page 29, in place of 800 rupees, it is 14,200 or the amount as decided by the government by notification from time to time published in the official gazette. So this amount, my lord, in place of 800 rupees, it was in 1967. So it was right according to the stamp valuation of the land, benchmark value and Stamp Act.
let us see subsection 4, subsection 6,
Subsection 4.
You are challenging that provision.
Provision.
Yes.
So far as quantum is concerned.
So far as quantum. you are
Only
challenging-
quantum. So, my lord, the page 26, I have annexed the old act, my lord. Page 26, 6, subclass 6. While making an order under subsection 5, the revenue officer shall determine the compensation.
Please come to your prayer portion.
My lord.
We are Odisha Land Reforms Act.
Section 4, subsection 6. Page while making an order under subsection 5, the revenue officer shall determine the compensation in respect of the land which shall be N.
You are challenging section 2, clause C.
Plus C of the present
Section
act.
2, clause C of the Amendment Act.
Amendment 2023, which is
Your prayer is not so very perfectly couched.
at the rate of 800 rupees. So 1967. So it was right. The amount of compensation was right according to the stamp value. So presently, my lord, the 2023 Amended Act, in place of 800 rupees, page 29, it is only 14,200.
Where is that? Where is the provision?
Well, page 29.
It's not there in the new book, this book. Is it there?
So, my lord, so benchmark value is presently 49 lakhs 50,000. So we are so very fixed determination of very low amount in deviation to the my lord stamp rules and act. Only 14,000. Same.
What is this Odisha law review?
My lord?
This Odisha law review? This should stop publishing such books. The publisher should be stopped publishing books, law books, because these are misleading. We will record that in the present order. The book, it's misleading. The amendment is not there. Law books cannot be so casually published.
Next of 3.
These. Well, Annexure three.
So many things, so many cases we are finding it.
My lord, perhaps it is not printed because last edition in my book.
This is 2023.
Mr. Mahanti.
My
Yes,
lord.
if you come to page 28.
What is
There's a
a
notification.
what is a land report?
29th So in absence of, it comes with effect from at once. In section 1, there is no subsection 2. Like other, the legislature has not given you the power to appoint a date of effect. So this amendment act comes at once.
Yes, that appears to be.
So as per General Clause Act, the day it is gazetted.
Yes, ma'am.
So effective date is 29th
29th December
2023.
Yes.
So Clause C, section 2, by virtue of section 2 of that amendment, Second Amendment Act, section 4 of the
Section
Odisha
4.
law, section 4 of the Odisha
Clause-
land reform.
Clause C, section 4,
The-
subsection C has
Ah.
been amended. In
Yes.
place of 800, 40,000 and 200.
In this book, that is not carried out. That is
Yes, that is perhaps it is not.
2020, this is 2023. These amendments came in December 2023. So that is the reason why it has not been incorporated.
Printing must have been prior to that.
Prior to
This book is printed prior to this.
Prior to the
Right.
amendment.
So you should have brought the notice of court. We are raising certain objections. You should have. That's why I said the
Mhm.
prayer is not
That's it.
properly caused. What have you said in your prayer? You have said section 4 of the Amendment Act. It is not section 4 of the Amendment Act. That is already incorporated. If I read your prayer properly, subsection 6, subsection 4 of paragraph C of Odisha Land Reform Second Amendment Act 2023. It is not that. It is section 2 of the Amendment Act, which you want us to quash.
According to Annexure 3.
Yeah.
No, my lord, section in the amendment, in amended section, it is incorporated in 2, but the legislature
incorporated
is
in 2.
intended to bring the amendment under
So what should have been
subsection
the
C. So, my lord,
section 4, subsection 6, clause C of the Odisha Land Reforms Act as amended
By section 2 of
so that should have been your
2 subclause C.
anyway.
Yes, what is wrong in this act?
my lord, the in place of 800 rupees per acre, so the minimum price is given. So in 1967, 800 rupees was fixed, determines compensation to be payable to the landlord as per the Stamp Act. My valuation, benchmark value of that by that year. So after 1967, the benchmark value and market value is being increased. So as per section 31 of the Indian Stamp Act and rule 37 of the Odisha Stamp Rule, rule 37, Odisha Stamp Rules. So district valuation committee is to be appointed to see the present
council. This provision is ultra virus what?
As far as determination of compensation is concerned. So
Compensation is not law. Compensation is not constitution. According to you, this is ultra virus. This is ultra virus what?
Because at the time of
Because will not do. You will have to say this provision
Yes,
is ultra virus, article so and so of the constitution, provision of any other law which is binding.
Well, the Odisha Stamp Rules 952, at the time of valuation of the my lord land,
It's very difficult for us to convince you. Yeah.
Rule 37.
Nine series. Nine series. Nine series, they cannot. Present. Petition filed under Article 226 of the Constitution of India has questioned the validity of Section 2 of Odisha Land Reforms bracketed Second Amendment Act 2023, by which following subsection has been added to Section 6, subsection 6 of Section 4 of Section 4 of the Odisha Land Reforms Act 1960. First off, Odisha Land Reforms Act 1960 falls under item 52 of the 9th schedule of the Constitution of India. First off, Land Council appearing on behalf of the petitioner has attempted to submit that the said amount, that the said amendment amounts to violation of fundamental and legal rights under the Constitution. First off, the said submission is untenable in view of the clear provision under Article 31, capital B of the Constitution, which reads as under. First off, this application is accordingly dismissed, being devoid of merit. There you find a decision, you must find a decision, you must find a decision. Yes.
Item number 20.
My lord, government is left with the discretion to enhance the compensation from time to time. So.
No, you have challenged the enactment, we have rejected that.
I don't, my lord, so we may approach the government because.
We cannot say anything. So virus, therefore it has come before this court. Don't know what will happen in.
My lord, with due respect, my writ petition, I want to withdraw the writ petition.
No, sorry.
Because the government has left with the power to enhance the compensation from time to time.
Counsel, be careful while filing a writ application. You challenge the validity of a provision under the Land Reforms Act.
So far compensation is concerned, only the compensation.
Mr. That cannot be separated from the Land Reforms Act. What you are challenging is part of Land Reforms Act. Are we clear? So the moment you challenge any provision of the Land Reforms Act, we will have to examine 9th schedule of the Constitution. Had you examined 9th schedule? Do you know the ground on which you can challenge a provision, challenge those provisions which are saved by Schedule 9? Challenging a provision of statute is not an easy task. It's very difficult. Yes.
May it please your lordship. Lordship, this is related to issuance of NOC of my nursing college.
Yes, sir.
Lordships.
Please come
Lordship.
again.
Lordships, this is related to issuance of NOC of nursing college.
Over.
Lordship, Lordship, over. Let liberty may be given.
Counsel for the petitioner seeks permission to withdraw this application.
Lordship, for the next academic year 24-25, I
That
may.
is also over.
That's already over.
Lordship, that
Time is over. You cannot make an application. If you have made the application, they will process that.
But I have deposited money.
For 2023-24.
But due to their defect, the cause of inspection couldn't be met.
Is there any provision that if no inspection is made, your case shall be considered for 2024-25?
But this year inspection has not yet completed. Though I have not, I may be allowed to, liberty may be given me to apply.
How can you apply if the date has lapsed? You should have applied. We can't do anything. The issue raised in the present writ application relates to the petitioner's grievance against the state of Odisha for not taking any decision on petitioner's application for grant of NOC for a nursing college.
That's it.
A nursing college. For the session 2023-24. Stop. It is an undisputed fact. It is undisputed that with the lapse of time, the petitioner's claim has become infructuous as no direction can be issued in the background of the cutoff dates have been prescribed by the Supreme Court in this regard. Yes. Stop. Next. Learned counsel for the petitioner, however, submitted that the petitioner may be permitted to that the state of Orissa may be directed to consider petitioner's application for grant of NOC for the academic session 2024-25. Stop. It has been stated at the bar that the time limit, the cutoff date for making application for grant of no objection certificate for the academic session 2024-2025 has also expired. Yes. Stop. In such circumstance, the court can neither issue any direction nor grant liberty to make an application after the cutoff date. Liberty to the petitioner, liberty to the petitioner to make an application. Stop. This application is accordingly dismissed. And State of Odisha and DA, what is
DMT, Director of Medical Education and Training,
Training.
Directorate of Medical Education and Training.
Yes.
What is the cutoff date?
Cutoff date, January 2024, my lord.
And you are in April.
But they can consider right now.
They cannot.
That's yet there.
The court will stop them.
This year we are not
Cannot
doing
consider.
anything. This year we are
Because
not.
the inspection procedure has not yet completed. Other institutions.
For the future, we'll lay down something.
Let's say they may consider my
They
grievance.
cannot, sir. If there is no application, they cannot. If you have any law which you can show, it's a different matter. Otherwise,
No law is there.
Forget. Both the cases.
Item number 21.
Page 21 is the impugned order, man. I'm so sorry, page 15, bro. I'm so sorry. Page 15 is the impugned order. People find here, it's a revision before the revisional authority filed challenging the lapsing order under Rule 28 of Mineral Concession Rules 1960. Now,
why this has come before us?
Because it was before the assigned bench, the honorable assigned bench said that they are concerned. Page 15 is the impugned order, my lord.
Annexure 1.
Annexure 1. The revision was filed challenging the lapsing order. There was an interim order passed.
What is the lapsing order?
Beg pardon, my lord.
What is the lapsing order?
Lapsing order. Lord, Rule 28 of Mineral Concession Rules 1960. Lord, that's on the arising out of 1957 Act, Mines Mineral Development Regulation Act 1957. That corresponding rules is Mineral Concession Rules 1960. Lord, I am not taking your lordship to the grant of lease and procedure. Once a lease is granted, if the lease is non-operational for a period of 2 years, then the authority will pass an order of lapsing. They have a power of condonation if the lapsing is not attributable to the lessee. Am I clear, man?
No, now it's
now, Lord, the lapsing order was passed. I have suffered a lapsing order. I preferred a revision in terms of Section 30 of the Act, my lord, before the revisional authority. Before the revisional authority, Lord, State took time to file a reply from 22 September 23 to 26 February 24. 22 September 23 to 26th of February 24
Took time for,
filing of reply.
so they kept on taking time or?
Time for filing of reply. Now, page 34, if Lordship would kindly take the pen of turning to page 34. Annexure 13 says, page 34. Lordship will see here, the revisional authority passed an interim order in my favor, that is on 23rd of February 24.
Just, which annexure it is?
This is Annexure 13 series, page 34.
Yes.
Lordship may see the last line. In view of the above, state government is asked not to take any coercive action till next date. This interim order was passed on 23rd of February 24.
Yes.
Now the state filed counter, my lord, on 27th of February 24. That is at page 23.
At page?
Page 23, madam. I'm so sorry. This is that email file counter on 27th
page
36. I'm so sorry. Page 36. Annexure 14. This is through email. They communicate us through email. Man. So daily they communicate us through email. This is email dated 26th of February 24. Annexure 14, page 36.
Certain attached documents are there.
Right, my lord. Right. As directed in hearing, state government comments available in the ministry is enclosed for kind perusal. They have communicated us on 26th of February 24. Now on 23rd of February, what you may see, my interim orders are vacated. I wanted a time for rejoinder.
20?
The 22nd of September 23. For the first time it came, I applied for a rejoinder. Just give me a small time for filing of a rejoinder. I'm so sorry, my lord. 12th of March. I beg excuse. I beg excuse. I beg excuse, my lord. I was wrong on the date. 12th of March 24.
26th February 2024, you got this letter.
Right, ma'am.
By email.
By email. 12th of March 24. That's the impugned order. I wanted some time to file a rejoinder. The revisional authority vacated my interim order.
Yes.
Lord, my humble submission is this order is without assigning any reasons. Lord, I am just seeking a time to file a rejoinder before I reply to the counter. It's a substantial right of lapsing of my minds.
No, which order is the final order? Which
Page-
order you are challenging?
Page 15, my lord. Page 15. 12th of March 24. Page 15, Annexure 1, I have shown to my lords.
11th, you sought for time.
Right, Lord. I just wanted a
11th. On 11th, you sought for time.
yes, by submitting a petition. Eleventh of March 24, I'm grateful, I'm deeply obliged. That is at page 37.
Case was not posted on 12th of March.
It was. It was.
But what happened on 2nd of April?
Lord, then we have been taking time because we are supposed to challenge this order. After it is
Why
pending.
did you challenge the order? You could have got the matter adjudicated.
Lord, lapsing, if they vacate the stay order, the deputy director is trying to take over the mines from me.
No, but since you could have taken this plea that now since you have vacated the interim order,
Without,
you should decide.
I'm grateful, Lord, but my pleadings in the shape of rejoinder should be there because this involves factual aspects. So I wanted just a breathing space for that.
No, but where is the rejection? Is there any order that you shall not be allowed to file rejoinder?
That is page 15. That's all. This is the order.
No,
No, they have not restrained me from filing up a
you
rejoinder.
could have filed your rejoinder.
Rejoinder, I can file it. That's no problem in that. Immediately I can file the rejoinder within a day or two.
So you do that.
I'll do that, Lord. Only just protect me, saying that this order of bracketing the interim order, Lord, has prejudiced me.
No, this order was passed on 12/3/2024.
Right, Lord.
You did not, even after this, you did not file your rejoinder.
Lord, I
So
think
therefore, he observes that you have obtained an interim order and thereafter you are not
this is
doing.
for the first time after counter this came.
All right.
Lord, your Lordship may see they took almost 1 year time to file a reply. Now, after filing up reply, for the first time it came. Lord, obviously, my Lord, your Lordship normally grants time, my Lord, for the purpose of rejoinder. Your Lordships also usually grants time, my Lord, a week time or even 3 days, 2 days, whatever time.
Again, it was agenda 2/4/2024.
Normally, your Lordships are kind enough to grant us time.
That is gone also. This is the last line. The case
Who
is
has to
adjourned.
decide it?
Next reflection.
The regional authority, same authority, my Lord, the additional secretary and regional authority, Shastri Bhavan, New Delhi.
And when was that file? The reply by the state?
The reply was filed, communicated to me on 26th of February 24. February 24.
So what rejoinder did you want to file?
In fact, they are all, I am not, what in fact they wanted to insert. I cannot. Just for a little space to come back to the same authority, I can do it within a day or 2 or 3 even.
You can do that. We can give you this.
But this interim order, bracketing this interim order, Lordship may kindly consider. He should not be so harsh because it is for the first time after counter it is coming. For the first time. And they have taken 1 year time to file their reply. Not one date for me, one date. Lordship usually grants me. Lordship are not, I have seen the Lordship usually grants time to file rejoinder. In this court also.
Me and
When your Lordship grants time even a week to file a rejoinder, this statutory authority, my Lord, can't be so.
Yeah, why it happened?
My Lordship may seek the next date was fixed to 2/2024 thereafter.
Then what
Lordship is the same order.
What happened on that?
On that day, I didn't have any instruction. That's why. But in that day, they can also file a rejoinder and I pray for the time for interim to be extended.
No,
if they agree with this non-filing of the rejoinder and
No. See, an interim order was granted in their favor. You were required to file your reply. You filed your reply on 26/2/2020. State.
We are the revenue authority. Government of India is the revenue authority. State says by the counter. Their grievance is that they want to file the rejoinder, which will not given time and interim order is vacated.
Why? Time was not given.
But my lord, thereafter, Lordship may see the
Had
next
they
date
been
was
seeking
fixed to
2 months
2/2024.
time, 4 months time, the matter would have been different. It could have been
As that
mentioned.
it is unreasonable. I understand the issue, but in the revisional authority, there is no scope to file rejoinder. Revisional only their
right.
finding decision they will given. There's a question.
Question of rejoinder, Mr.
That's their required.
In revision case.
They grant time in every case.
Maybe granting time, but in revision, where is the question of the limited scope of revision?
Lord, since a factual aspect to be inquired into, my lord. They are all based on facts.
No, facts,
Lord,
all facts are there.
In the counter, they have certain stated facts, man. So that is required.
We find some bona fide in the order because the revisional authority is of the view that after having obtained the order of a stay,
we have never taken time. After having obtained stay order, we have never taken time. We have never taken time. This is only single instance. Only. Lordship may be kind enough. Valuable right of a person, one chance may be given to me. One chance, just a
Chance is
chance.
there. Chance is there, we can say that you should decide the revision petition within
That's
1
right.
month.
Lord, restoring this protection. Kind.
No, why 1 month? We are directing them to
Lord,
dispose it off.
in that case, Lordship can hear, Lordship in exercise of 226 can say that till that period I may be protected. Till
No.
that period, Lordship can protect me, my lord. Lordship may target it. Lord, time-bound manner, I'll do it, my lord. I'll do everything in a period of fortnight, whatever your Lordship would direct.
No, we don't know what will you do in the meanwhile.
Lord, I'll definitely obey my lord's order, my lord. Completely I'll obey, my lord. I'll 100% obey your Lordship's order.
Yes.
In fact, I have defended the lawsuit here, prayed for passing of Annex 1 and 2. 2 cannot be posted. Where 17 Annex 2 cannot be posted here because it was passed from 1 to 424. The prior notice was issued to the appear before the authorities, and the interim order was passed subsequent to this. Now this is matter. So how will you challenge Annex 2 Milo? Only Annex 1, he may say that no time was granted and the interim order was vacated. If the notice is there, Annex 2 is also under challenge.
2 is the consequence of Annex 1. That is why I am seeking protection. Kindly see me.
So it's a notice, you hand over or you appear before.
So then my revision becomes infructuous. Then my revision goes, man.
Maybe. You made your revision.
Lord, single date, Lordship will kindly appreciate.
No. See, mister, he did not refuse your prayer to file the rejoinder.
Beg pardon?
He did not say the
No, he is restraining me.
But you did not do.
But I am not agreed by
Still, you have not filed rejoinder.
But even today also I can proceed, man.
No, but why did you not file?
Lord,
When the court is to exercise writ jurisdiction, then the court will see the conduct of the party also.
Second of April, they had the opportunity to file.
You could have filed.
Lordship may skip over the issue of rejoinder. I may also proceed without a rejoinder, but this protection should be there. Otherwise, this
Annex
Annex
difficulty. Now you are saying that you may proceed without rejoinder.
this Annex 2 kills me, man. Annex 2 kills me. Unless I am protected for a particular period, I am there. I am not going away from the hands of Revenue Authority, my lord. Do your Lordship really not feel that they have become harsh enough against me, man?
No, this order was passed in the month
12th of March only, my lord. 12th of March only.
March only, no, March.
My lord,
12th March.
My lords may be kind enough, Lord. Otherwise, Lord, where these people will go? Your Lordship will consider.
How much time will you take to decide?
My lord, this order shows that they are ready to hear the matter and it will conclude.
Next day, whatever date.
May I pray one thing, my lord? Lordship, keep it pending for next week. In the manual, take instruction of how many days we will conclude the revision. They have a liberty to file the revision and
file the rejoinder.
Rejoinder and
file the rejoinder.
Rejoinder and in the meanwhile,
File the rejoinder.
I'll definitely
file it tomorrow, and we will take up the matter a week thereafter.
Yes.
April,
This matter on 1 week. Meanwhile, the petitioner shall have liberty to file rejoinder before the divisional authority, that is additional secretary. Mines. Steel and mines. Do that. Additional secretary, so respond number. Let it come. The first 5 cases.
Ajalt.
My lord is fixed to next week, man. Next week, my lord.
1 week.
1 week.
It goes without saying that once a rejoinder is filed, the divisional authority shall be at liberty to proceed
That's it.
and pass out in the product law. In the revisional case,
Item 22.
Since your Lordship has shown little Lord indulgence in the matter.
We have not shown.
Lord, even without any order, since now State Council is appearing, Lord, I'll expect that they will not be harsh in this period, Lord, without an order. I expect that State Council.
He may do otherwise. You
Your
should not have given this hint.
Your Lordships are there to protect me.
Yes. Next.
Item number 22.
May it please your Lordship. It's a tender matter. If you also look at the last order that has been passed,
4/4/2024. Person. Sir, sir, should have been there, but the lordship directed that the matter should be placed for lordship.
No, but virus of any statutory provision is not under challenge.
Only the clauses incorporated in the terms, so that is not, it's not.
Right. It is only a few clauses actually I am challenging, which is unconsignable. If it is unconsignable, your lordship knows that the court can also intervene. But
Court can intervene, but whether the roster which we have, we can do that.
I also insisted that my lord should take up that. Justice Rading should have taken up, my lord. But he said, no, let it go to Honorable Chief Justice. Your lordship may hear this matter. In any event, it doesn't make any difference, my lord, but your lordship can also take up the matter.
No, but paragraph 4 is disturbing us.
So virus actually is not exactly the virus. I also informed the Honorable Court. And interestingly, there are 3 flaws in the tender document. We raised objection. Then they issued addendum, that is Annex 17, and they corrected 2. The third one they didn't correct.
This matter has been listed before this bench in the light of an order by coordinate bench of this court dated 4/4/2023. First off, as per the roster, where is the contract matter mentioned? This must be tender contract.
Yes.
The writ petitions relating to tenders. क्या लिखा? As per the constitution of, as per the assignment, as per the roster, the writ petitions relating to tenders are to be heard by the division bench which has passed the said order dated 4/4/2023. Stop. The writ petitions on validity of statutes, as per the roster, are to be taken up by a bench by a division bench presided over by the Chief Justice. So stop. The coordinate bench. The matter has been placed because of the aforesaid observation made in paragraph 4 of the order dated 4/4/2023. Oh, stop. We don't intend to enter into hyper-technicality as regards assignment of matters. As per the roster. Here there is a change. Yes.
I can proceed, my lord. My lord, may it please your lordship. Lord, can I have a look at annexure 4 at page 46? Just one line before that, page 49, let's be kindly first. Annexure 5.
Annexure 4.
Annexure 4, this is the request for bid. Selection of successful bidder for design, construction of automated testing station, procurement.
Sorry, I could not get that. Page 40,
There's 49, my lord.
49.
No, 49. No, 49.
You are referring to Annexure 4.
Phase 49 is the request for bid. The nature of work actually I wanted to show you, lordship.
Yes.
For which the bid was floated. Selection of successful bidder for design, construction of automated testing station, procurement, supply, installation of vehicle testing equipment and operation and maintenance at 21 locations in Odisha state. But the petitioner happens to be from 2015 throughout India, more than 102 places in India, different states they have done, and they have tested about more than 30,000 vehicles. They're the expertise in the subject itself. So they are one of the bidder. But if your lordship kindly look at now 46. But I twice came before your lordship because on 5/3 I gave a representation after the pre-bid meeting. In the pre-bid meeting, I pointed out 3 clauses of the bid document which is unconscionable. I'll show your lordship those clauses. Then they kept it pending. Then I filed a writ application. On the writ application directed, my representation should be disposed of within 3 months. They tried to proceed with the matter. In the meantime, they modified by extending the period of the bid to 16th. Then I filed another writ application that they have modified this but not modified the other 2 clauses, which is unreasonable, absolutely unreasonable, unacceptable as such to the Honorable Court even. Then Honorable Court said now they have not disposed of the matter, directed them to dispose of within 3 months. So since 16th was the last date, I applied without prejudice to my right on the bid document. I filed all my documents. I complied with all the requirements. But kindly see at page 46, they rejected me. There are only 3 bidders. They kept 2 bidders alive and rejected my bid at page 46 if your lordship looks at. A single line has been passed. The following tender, your form fee, kindly mark, form fee has been rejected
Kindly visit the site for more details.
Page 46.
Page 46. He said, dear sir, madam, for following tender, your form fee has been rejected. Kindly visit the site for more details. The next page, kindly turn. No other reason has been given. Next page, page 47. The box itself shows tender fee amount submitted by the bidder is INR 10,000, which is less than the requisite amount of INR.
Where are we reading?
So 47, page 47. Tender fee amounting, that inside the small box it is mentioned.
Yeah.
Tender fee amount submitted by the bidder is INR 10,000, which is less than the requisite amount INR. So next page, kindly see. Page 48.
Yeah.
Disqualified reason. This is the reason for which I have been disqualified in the tender document. 10,000 plus applicable tax comes to 11,800 as per section 1, table 1, serial number 7 in the RFB. So now come to page 52, Marad.
Yes.
Page 52, serial number 7, they are referring to, Marad, in that page 47. Bid processing fee. It is not form fee, it is a bid processing fee. 10,000 bid processing fee plus taxes as applicable bid processing fee shall be paid in online portal being used for tendering. It has to be through online portal method. I cannot just pay in for any other mode. If you also kindly turn to page 53. The online portal is enivida.orissa.government.in. Top method 2.1. It's enivida.orissa.government.in. Instruction to bidder for participation in tender through enivida.orissa.government.in. So kindly turn to page 55. Clause A. The bidder shall ensure all the requirements specified in the RFB are duly complied with. So next page, page 56. A, Malad, top Malad. The bid shall be accompanied by EMD of 80 lakhs. EMD shall be paid in the shape of demand draft drawn in favor of Transport Commission Orissa, issued by any nationalized bank, payable at Qatar, shall be attached along with the technical bid of the tender.
You are reading which one?
Press top Malad. A, 50 page 56.
The bidder shall ensure. 50?
A, Malad.
56.
Page 56,
Oh,
small a, Malad.
Small.
The bid shall be accompanied by EMD of 80 lakhs. EMD shall be paid in the shape of demand draft. Then, sir, come to page 2.9. Bid processing fee.
2.9
Malad.
clause. Yes.
Bid processing fee. The bidder shall deposit bid processing fee of 10,000. Processing fee plus taxes as applicable. The bid processing fee is non-refundable. A bid which is not accompanied bid processing fee shall be construed as non-compliance bid shall be summarily rejected. Bid processing fee shall be paid online on tendering portal. That is e-Nibida. Then submission of bid also says the bidder should visit small b, Nibida site, follow all the necessary guidelines for online submission and shall also go through the digital signature requirement as well as system requirement. So kindly turn to page 79, Malad.
Page 65 also.
Right. So manner of submission is page 65, page 2.13. Page 65, Malad. 2.13. The bid shall be submitted through online mode on the e-Nividha procurement portal, which is the due date and time submission. Page 79, Marad. This is the portal format, Marad. At page 79, Annexure 6.
Yeah.
Sir, kindly see on the left-hand side column, it says tender processing fee 2,950. Left-hand side, Marad. After 16/3/24, date, time, closure of the time, tender processing fee TPF 2,950. Though it is mentioned tender processing fee is 10,000. Sir, it is mentioned right side, form fee to be deposited is 10,000. Doesn't speak about any tax. EMD is 80 lakhs. Malad got that in that. I have to follow this, Malad. I cannot follow any other portal or any other document. But if your lordship looks at.
So how those persons who became successful, how they could deposit?
Sir, I have to deposit all these things mentioned in the e-portal. Nothing else. I have deposited.
As per advertisement, form fee
Yes.
includes GST.
Yes, I have paid, deposited, Marad. Sir, look at page 100 and page 192, Marad. Page 192.
File your affidavit.
No, it's not office, it's state transport authority. I'm looking for one.
Already we will take up tomorrow.
Tomorrow.
Mr. Prabhakar Behra.
Please come, please request him.
Tomorrow.
So I plan next week I plan next.
No, it has been complied with and
Lordship, I am sorry to mention one matter. Your Lordship may allow to mention one matter, Lordship.
Make a mention tomorrow at 10:30.
Lordship, item number 5050.
This is not the time to mention, Mr. Counsel. Make a mention at 10:30 in the morning, or if you have to make a mention at 4:30. This is not the time. It is stated by learned AGA that this court's order, violation of which has been alleged in the present contempt application, has been complied with. Stop. He has filed a compliance affidavit in this regard, a copy of which has been taken on record. A copy of the said affidavit has been served upon learned counsel for the petitioner. Stop. Who is present?
Yes, sir.
The contender. What is your name?
Vishwanath Tarai, District Education Officer, Quota.
Mr. Vishwanath?
Sir, Vishwanath Tarai.
Vishwanath Tarai, District Education Officer, Quota.
So, Vishwanath Tarai, the District Education Officer, Khurda, is present in court. Stop. Considering subsequent conduct of the contender and other facts and circumstances available on record, the contempt proceeding is dropped. Yes.
Item number 53.
My lord, may it please the lordships. This is an appeal by the state, my lords.
Yes.
And let me give you lordships the flavor of the case, then we'll come to it.
Just a minute. Why are you? क्यों खड़े हैं आप? किसमें?
He is in this item probably.
Yes, sir.
क्या हो गया आपका?
कौन तो कौन?
Sir, this policy is not implemented today. Are you party to this? Are you party to this? I'm an interim application,
He has filed an intervention application.
752.
आप बैठिए सुनिए, जरूरत होगी तो आपको बुला लेंगे.
But your lordships are aware, my lords, that the RTA Act was enacted and pursuant thereto, my lords, there were a large number of schools which were set up in various states. And your lordship, they only note, my lords, there is a category of schools which the government of India has categorized as suboptimal schools. And we will come to that a little later. So the policy has been of the government of India that there should be rationalization / consolidation of suboptimal schools. And that's a national policy. I will take your lordship's call. In the state of Orissa, a policy decision was taken that if you have a school which has 40 or less students, then you rationalized or consolidate it with another school. And that school will be called the lead school, depending on what kind of infrastructure it has, etc., etc. Number one, petition was filed before your lordships, which is the lead case, where the petitioner comes and says that the school to which, let us now call it Amaramunda, the first appellant, and that was to be merged with another school called Lakshmanpalli, because that is the only case which has been adjudicated by this honorable. So there are two schools we are talking about, Amaramunda and Lakshmanpalli. And the petitioner said, my lords, that this is violating the distance norms between the schools. And therefore, it says that this consolidation is bad in law. Now, I will tell you, lordships, what is the distance norm. My lord, section 3 of the RTA Act says that there should be a school within 1 kilometer of the neighborhood. I'm sorry, my lord, I'm sorry. It says there should be a school in the neighborhood. It does not say what is the distance. It leaves it to the respective state governments to work out the distance. Now in Odisha, there is a rule framed called Rule 6. And that rule says it should be 1 kilometer from the neighborhood. So the petitioner comes and tells your lordships that this new school which you are now merging us with, namely, you are merging Amaramunda with Lakshmanpalli, that hits the distance norm. That's the case. A counter affidavit is filed by the state, inter alia stating that the distance between the two schools is 0.8 kilometers, and therefore it is well within the prescribed rule. And to substantiate its case, it files a report, a joint report, inspection report, inquiry report, I'm sorry. Your lordship may only note, my lord, it is dated 19th March 2020. I will show that document to your lordships, which is annexed as annexure BY1 to the counter affidavit, saying that the distance is 0.8 kilometers and therefore well within the rules made by the state government. And I will show your lordships the writ petition. It relies upon a Google map, not authenticated, as required under section 65 B. But be that as it may, that is all that was before the learned single judge. The learned single judge goes on to hold. He renders as many as 10 findings. Your Lordship need not write it, I'll tell you Lordship what they are. What the learned single judge holds is this, that there is no provision under the RTE Act which permits consolidation / rationalization of schools. That is the major finding in this case, which we are challenging. The second finding is that you have devised a method that a suboptimal school, namely a school which qualifies for merger, should have a strength of 40 or more. That also I do not see anywhere under the RTE Act. The RTE Act does not say that if there is a school with 40 or less, it can be merged, or it can be consolidated, or it can be, as your Lordship said, rationalized. The third finding is there is a schedule to this act, and that schedule does not say that what should be the minimum roll strength of a class. Because the schedule says that for every 60 students, you should have 2 teachers. So therefore, the schedule does not say that there should be a minimum strength in a class, otherwise it should be rationalized. So that is the third finding. Now, my lord, the fourth finding is that because the distance is more than 1 kilometer, it violates the rule 6.1 of the rules, of the Orissa rules, namely, there should be a school within 1 kilometer of the neighborhood. While arriving at this finding, it discards my inquiry report and believes the Google map filed by the petitioner therein, respondents here. So broadly, my lords, these are the 4 findings. And then there are some ancillary issues. This policy, which the state government framed, also had a guideline. Now, that guideline stated that if you are aggrieved by any decision, there were 2 stages where you could go and make a complaint. One was at the district level, and one was at the state level. For example, and most of the cases are that, suppose I come and tell your lordships that this school had 42 students, and therefore you have wrongly clubbed me as a 40 and under. I could go and make a complaint to the GRF, failing which I could make a complaint to the state government. And if the state government, I will show you lordships, these things have been attended to also, not that it has not gone attended. But what the learned single judge says is that since they are officers of the department, going there is an empty formality. In other words, it is not efficacious. Every day your lordships have seen under the various fiscal statutes, be it sales tax, income tax, central excise custom, there's always a departmental hierarchy. And my lord, the last finding, if I may say so, is that because this policy violates the RTE Act, it is liable to be struck down. So therefore, my lords, if your lordships accept my submission that there is no prohibition under the Right to Education Act for rationalizing / merger of schools, my lords, then the fulcrum of the finding of the learned single judge goes. If your lordships agree with me that if there is a Google map unverified, as understood in law, versus an inquiry report which says the distance are different, your lordships could still ask me to make a further inquiry and find out which one is right, but that would by itself not invalidate the policy. Implementation of the policy is one thing, invalidating the policy is another. Shortly put, Lord, this is the canvas of my whole case. Now, if your lordships may kindly see, my lords, let us see, my lords, how this.
This 0.8 kilometer
Yes, my lords.
is from Ammanna to Lakshmanpalli.
Yes, I'm grateful. I'm grateful. Let me show your lordship straight away the document.
No, I'm
Yes,
saying something different.
I know.
Suppose there is a place
Yes, my lord.
from which this Amarna is 1 kilometer,
Correct.
and you are removing this
Yes,
to this, which is further 0.8 kilometer.
correct.
So it is not that it is within 1 kilometer, it becomes 1.8 kilometer.
I'm grateful. I'm grateful. Your lordships have posed the correct question.
This
Let us
may be a situation. It may not be. It may be.
I quite appreciate that, my lords. Because that was the finding which the court was liable to render, namely that this new school is not within 1 kilometer of the neighborhood. Because this section says that you must have a school in the neighborhood. And what should be this distance is left to the states to decide. Most of the states have gone by this 1 kilometer rule. And they have said, in case of certain exigencies, you give transport allowance, etc., etc. But the norm is that. The finding is not, my lords, that this school is beyond 1 kilometer of the neighborhood. The finding is the distance between these two schools, I say it is 0.8 and the Google map says it's 2.9 or something. The question which your lordships put to me is very apt. The answer should be, what is the distance from the neighborhood, not what is the distance between the two schools. So that is a question of fact, my lords, but unconnected with the validity of the
And then can
policy.
be another circumstance. Suppose there is a place.
Yes, my lord.
Between this, what is Amarlanda or what is this?
Amarmunda.
Amarmunda and Lakhanpalli.
Lakhanpalli.
So there can be some place just in between the
Correct.
two schools.
Absolutely. Absolutely. My lord, if the petitioners.
So that is not the criteria. The distance between the two schools
is not the criteria at all.
Be the criteria. Criteria should be as to how much places this Lakhanpalli is
from the neighborhood.
Cater.
From
Yes.
the neighborhood. I'm grateful. I'm grateful. So therefore, as it rightly fell from your lordship's lords, what is the scheme? The scheme is a student from the neighborhood should have access to school. And most of the states have said it should be 1 kilometer from the neighborhood. The question is not what is the distance between the two schools. And assume that the distance between the neighborhood and the school exceeds 1 kilometer, then you are violating Rule 6. So that's a matter of interpretation or application of the policy. Lord, am I clear, minutes? The policy is consolidation. For schools having 40 or less students, the policy says that you have to abide by this 1 kilometer rule. If the school falls foul of that, namely your consolidated new school goes 1 kilometer beyond Amarmunda or the neighborhood, as it were, then it will be a misapplication of the policy or a wrong implementation of the policy. The submission to my lords is, for your lordship's kind consideration, can you fault the policy because of bad implementation? And therefore, my lords, the policy itself provided that if there is a wrong implementation of the policy, there is a two-tier method where you can go and make your grievance and have it corrected. And now if your lordship sees, my lords, the interim order which your lordship passed on the first day, it will have some relevance on this case. While admitting this appeal, where is the order? It is. That is order number 2, dated 20th of July 2021. My lords are pleased to have it. Order number 2, 20th of July, 2021.
Just a minute.
Yeah, I'm sorry.
Which item? Order dated?
Order dated 20th of July, 2021. And it is an order number 2. You don't have copies? Milord, may I slowly read it, Milord, but Justice Raman will not have a copy.
Yes.
Kindly see, Milord, paragraph 4. In the considered view of the court, since the impugn order of the Lord Single Judge quashes the policy decision of the appellants contained in the notification of 11 March 2020 regarding rationalization and consolidation of schools under the School and Mass Education Department and raises substantial questions law concerning the interpretation of the relevant provisions of the Right of Children to Free and Compulsory Education Act 2009 as well as the rules made thereunder to the applicable to Odisha in 2010 in light of Article 21A of the Constitution of India, the appeal would require consideration. Kindly look at IA order, Milords. In the present application seeking interim stay of the impugn order, the Lord Single Judge, it is pointed out by the appellant that approximately 7,772 government schools across the state which have been selected for consolidation. Nearly 4,800 schools have already been successfully consolidated and they are functioning without any objection from any quarter. It is stated that the impugn order is result in quashing the entire policy is sought to be implemented, require restoring. Your Lordship may leave all that, Milords. Kindly see, Milord, paragraph 7. Mr. So-and-so draws the attention of the Office Memorandum of 11 March 2020, setting out the implementation guideline of the above policy, which specifically provides for setting up a grievance redressal cell at the district level. Another state grievance cell at from the Orissa School Education Program Authority, which will examine the specific grievances of any party post-consolidation. It is noted that during the pendence of the writ petition, the single judge ordered status quo as a result of it. Rest is not relevant, Milord. What it said is you go there. You can go there if you so want. And para 10 Milords, in that view of the matter, subject to the condition that any party with a specific grievance regarding consolidation of schools can activate the grievance redressal mechanism in terms of para 24 of the aforesaid OM dated 11 March 2020, the impugn of the learned single judge shall remain state. So therefore, your Lordship said, if you have a grievance, go and approach the grievance cell. And that is a two-tier grievance redressal mechanism. Now, would your Lordships kindly turn to Annexure 1, page 87 of the guideline. Annexure 1, page 87. Because all that I am trying to do is submit before your Lordships that the principle of rationalization of schools or merger of schools or consolidation of schools is as per the policy framed from the Government of India from time to time. And that is what my endeavor is to show your Lordships. If my Lordship sees page 87, this is a letter of 7th July 2017. My Lords have it. My Lord Justice Raman has it.
Small schools across the.
I'm grateful. I'm grateful. Finalizing of guidelines, rationalization of small schools across the states for better efficiency. That is the subject matter of this letter. It is the letter of the Government of India, Ministry of Human Resources, Shastri 1, 7 July 2017. I am directed to state that one of the action points of the Department of School Education Literacy, Ministry of Human Resource Department, as a follow-up from the Prime Minister's review on so-and-so, and Niti Ayog's follow-up points relates to finalization of guidelines for rationalization of small schools across the states for better efficiency. The department has examined the practice of rationalization of schools underway in some states, and basing on the existing models of rationalization of schools, draft guidelines have been prepared and enclosed herewith for kind reference. I requested to kindly send your comments. Now, my Lords may kindly turn to page 90, which is the executive summary. My Lords, have page 90 minutes. When SSA is Sarva Sikkha Abhijan was started, there were a large number of habitations without any kind of schooling facility, and there was a huge infrastructure gap in the country, adversely affecting the goal of universal elementary education. The foremost priority under SSA was therefore to provide school in all habitations within a walking distance. Consequently, SSA provide for 1 lakhs of upper primary schools up to 2016-17. Came in force and so and so. The RT Act under Section 6 provide children's access to elementary schools within defined area limits of neighborhood. Further, the Act has laid down norms of standards which are required to be ensured in every school, including so and so. Paragraph 3, my lord, there are various reasons to suggest, kindly note, this is a little important. There are various reasons which suggest that a relook to the expansion of schooling facilities made in the previous years and call for a nationwide consolidation of schools. Kindly underline this, my lord. Calls for a nationwide consolidation of schools. These includes existence of surplus schools, schools with zero enrollment schools, with very less enrollment. Kindly note, with very less enrollment, existence of more than 1 schools in the same building, habitation or vicinity. States are now increasingly realizing that surplus schools in excess of neighborhood requirement have somehow been established, which are adversely affecting the provisioning of resources, teaching, learning process, monitoring and supervision. States such as Andhra Pradesh, Rajasthan, Goa, Chhattisgarh, Haryana, Himachal Pradesh, Punjab, Maharashtra have already initiated the process of rationalization of small schools. Analysis done by the states is revealed that if children and resources spread in 2 or more small schools are combined together with habitation, it will not only provide better teaching learning environment, but also make schools RT compliant. The rationalization of rules in these guidelines is defined as a participatory and consultative process for reassessing the need of schools within the stipulations of the RT Act in a given habitation. So, Your Lordship may now turn over the page minutes and kindly come to paragraph 7 at page 91. The guideline discusses, my lordships have paragraph 7, various provisions maintained by the RT Act 2009 for every school and correlation between the existing small schools and provisions of the RT Act. It suggests for a relook at these small schools in view of the RT Act stipulates that the best interest of the child. The guidelines make it clear that the process of rationalization of small schools will adhere to the neighborhood norms as described on the RT rules of the states and union territories. Now, my lords may kindly see the last paragraph. The guideline discusses both advantages of composite schools as well as the need and advantage of standalone schools. It makes it clear that the process of rationalized schools will not necessarily lead to merging or closing of schools. On the contrary, it may also establish the need of new schools as well. Now, my lords may kindly see the next page if you wanted me to show. Kindly see, my lord, page 94, the last paragraph. Access to school has been reconceptualized under the RT Act. It has brought a wider and more fundamental dimension to it. The Act provides for a neighborhood school located within the definite limits of neighborhood, which has been notified by the state. Your lords may skip all that, come to the last 5 lines, my lords. The RT Act thus recognizes, your lordships have it, it's in bold, thus recognizes the need for more functional understanding of access and goes beyond mere physical access to schools. Some critical aspects that should be factored in while discussing access to be fully functional school also include the availability of qualified teacher, functional toilets, drinking water facilities, playgrounds, etc., etc. Lord, in fact, today there is a judgment on live law where the Kerala High Court has said that if you don't have a playground, close that school. If my lords now kindly turn to page 95 minutes. Paragraph 5, reasons and rationale for rationalization of small schools. Before we discuss the detailed process of rationalization of small schools, it is pertinent that rationalization process, the justifications and reasons behind rationalization, its objective and principles guiding the whole process are clearly defined. Now, your lordship may see the next one, my lords, 5.1.1. My lordships have it, page 95.
Yes.
Kindly see, my lord, last 5 lines. It begins as a result. My lordships have that line, my lords?
Yes.
As a result, there are considerable number of schools with very less number of enrolled children or with zero enrollment, single teacher schools. Therefore, the states are now increasingly realizing that surplus schools in excess of neighborhood requirement have somehow been established, which are adversely affecting the provisioning of resources, teaching, learning process, and monitoring supervision. And if my lordship sees, my lord, page 96. My lordship may see, my lord, page 96, last paragraph. The common feedback from the states is that existence of surplus schools in the vicinity is causing to a considerable number of schools with low enrollment, poor infrastructure. The analysis done by the states has revealed that if children and resources spread into 2 or more schools are combined together within the habitation, it will not only provide better teaching and learning environment, it also makes the schools RT compliant. So therefore, rationalization or consolidation of schools is not something which Odisha government found from somewhere. This has been going on, this has been being discussed within various states and the central government, and they have come to the conclusion that rationalization of school is very much necessary, and in fact, that would render the schools more compliant with the RT Act rather than it will be opposed to the provisions of the RT Act. Now, your lordship may kindly see, my lord, page 127. This is a notification of 14th of May 2018, page 127, annexure 2.
Annexure 2 series.
I'm grateful. My lord, even before the impugned rationalization policy, which has been struck down in 2020, the Odisha government had a rationalization policy on 14th of May 2018, and that was never challenged. Kindly see this, my lord. Exponential growth of elementary and secondary schools in the state in the last 2 decades has undoubtedly resulted in expansion of schools. Of access to schools, and at present there is hardly any unserved habitation left in the state. But so far as quality education is concerned, there is still much room for improvement. One of the important factors affecting the pace of growth in quality education is lack of, I'm so sorry.
No, sorry.
One of the important factors affecting the pace of growth in quality education is lack of adequate number of teachers in many schools. Ironically, many schools are running with very less number of teachers in our state, although it is highly favorable that the parent-teacher ratio is 23:1. What is PTA? Not parent teachers. Against the RT norm of 40:1. This is the reason why continuous efforts are being made in the last 10 years to rationalize the teachers. But rationalization of teachers alone has not solved the acute problem of vacancy of teachers in many schools, especially those located in rural and remote areas. The following situations have been found to be inhibitory in the stride towards goal of quality education. A, school with fewer roll strength and those with better roll strength have been provided with equal number of teachers to satisfy so and so. Large number of schools in the state that has not been able to provide at least 1 teacher for each class in elementary school as required in ideal situation. Thousands of primary schools are running only with 2 teachers. Large number of upper primary schools is running with 3 to 4 teachers. So saying, my lords, they conclude by saying rationalization of schools being one of the most effective ways of solving the problems caused due to the above situation. Steps have been taken in this direction in the recent years by merging schools and closing down many schools with very poor roll strength. Even those steps have been taken in the right direction. A comprehensive and strategic approach to the problem was required to be worked out to ensure so and so. So paragraph 2, my lord, initiative under the policy. The following are the major initiatives. One is merger of schools. Now, my lord, we come to page 158. My lord, this was the This was the notification which was challenged in the writ petition. And this has been quashed. The policy of rationalization and consolidation of schools under the School and Mass Education Department has been framed by the government and so department on 14/5/28, the one your lordship just saw. The objective of such a policy has been elucidated in the said notification. In view of the immense benefit of such consolidation in terms of improvement of quality education and efficient utilization of state resources, there is a continuous endeavor at the level of government to further strengthen the policy of rationalization, expand its scope, consolidate the process in order to achieve the following: make the schools aspirational with large peer group. These are little important. Make the schools aspirational with large peer group and adequate teacher per grade, improvement of pupil-teacher ratio, better infrastructure facilities in consolidated schools, better academic environment with TLM. TLM is teaching learning method, facilities, e-learning, co-curricular facilities, vibrant parent community. As enrollment increases, the PTM stabilize, improving learning outcomes, improving quality outcomes. Most of this has been taken from those Government of India documents. After careful consideration, government have been pleased to introduce a policy for rationalization/consolidation of schools in the following manner. We're at page 59. If you watch page 159, the principle, consolidation of schools, and what are the principles? If your lordship sees, Millers, 1A, government elementary and secondary schools having enrollment less than or equal to 20 to be consolidated with the nearby schools irrespective of the distance. So if it is less than 20, then irrespective of the distance. Now, what we are really concerned here with, Millers, is 40 and more. And that your lordships will get, Millers, at page 161, which is the table. Yes. Lordship may see, Millers, there's the paragraph 3, which says selection of schools for consolidation. Now, we are concerned with serial number 3, that is Amarumunda. It says, if you are less than 40 in non-scheduled area and less than 25 in a scheduled area, and the distance is 1 kilometer, it can be consolidated. So, my lord, the government in its wisdom said that if a school has less 40 or less children, then that becomes a suboptimal school, and therefore it can be merged with another school for the various reasons stated here in above. Now, what the learned single judge holds is that there is nothing under the RTA Act which permits such rationalization. So, this policy has been struck down as being violative of the provisions of the RTA Act. Plainly put, my lords, if your lordships agree with me that rationalization of schools, merger of schools, etc., my lords, is a well-known phenomenon, and it is a principle devised by the Government of India, by the Niti Aayog and Ministry of Human Resources, etc., that there are a large number of schools, they have to be rationalized. And it does not violate the RTA Act, and I will show you, lordships, it does not. Then this judgment has to go. Now, if your lordships kindly sees, Millers, just a few more paragraphs of this policy.
Your submission would be,
I'm grateful,
that if something is not specifically prohibited under the Act,
I'm grateful,
and if you take any policy decision,
I'm grateful,
so only because the Act does not stipulate such policy to be met, therefore that policy is bad.
I'm grateful.
This reasoning This is what you are submitting.
That's all. So let me straight away come to the act, my lord, without wasting your lordship's time. Your lordships will see, my lord, this act itself. So therefore, I have to show your lordship. Yeah, please.
The single judge has specifically found that the policy is contravening their rules, not the RT Act alone, but the rules. So that's the point. If your policy contravenes the rules, and here what would be important is that the central government rules. Central government rules also have this 1 kilometer template.
We will hear you, Mr.
Mellot.
No, my lord, that makes my task much simpler.
Yes.
If his only argument is that you are violating the rule, which is the petition.
This is what he is saying.
Then I don't have to labor so much. I will straight away come to rule 6 minutes.
Right.
I don't have to labor so much. But it is, so therefore, if all of us
That's
have an
the point.
agreement,
See,
if all of
both have statutory force, the act and rules both.
Correct.
So neither the act nor the provisions of the rule can be violated.
Correct.
So if any policy, if any scheme is contrary to either the act or the rule.
So therefore, my lords,
Our point is clear. It's contravening the rules.
Now, my lord, let me tell you, lordships, if I've understood my learned friend correctly, and my learned friends who are appearing for the other side, the finding of the learned single judge that consolidation per se is in contravention of the RT Act is one which is not being contested, then my life becomes much simpler. Because I'll show to your lordships, what are the findings?
Single judge says RT Act.
Yes.
RT Act read with the rules framed there under.
Well, my learned friend, to be fair to him, says that you are violating the RT rules to the extent the 1 kilometer distance is concerned. No difficulty. If your lordship, no, that will be on a case-to-case basis. Well, there could be a merger of school A with school B. That would result in more than 1 kilometer. But there could be a merger between 1 to A to 1 to B, A to B, which will be less than 1 kilometer. That won't hit the rule. But what the learned single judge says is, the very concept of merger is bad. That is not provided under the RT Act. So let me straight away come to the finding. And if we are together on that point, that was not a point under consideration, because to be fair to him, his writ petition was never saying that you cannot merge a school. His writ petition was saying that the distance norm has been violated, therefore rule has been violated. Well, I have no problem there. That's a question of fact. Kindly see, my lords. Let's take your lordship straight to the rules, straight to the judgment. And if your lordships are kindly pleased to turn to rules.
The fundamental idea is
yes, my lords.
Access to education.
I'm grateful.
And the things will depend on the availability of cluster of schools in an area.
I'm grateful.
So one school having 40 or less students, we are not commenting upon the legality of the scheme for the present, but the idea is that if there is a cluster of schools, all right, it will depend, of course, that to that extent I would agreeing with the learned Advocate General that if a particular village complains that there is no school within the radius of 1 kilometer, that can be looked into.
Correct.
All right. But only because the school to which the suboptimal school has been shifted or their children have been shifted, that may not per se be contrary to the provisions.
We will see. If I may take your lordship, we have filed a very short note. The basic point which fell for consideration before the single judge was whether you can have a policy which contravenes the rules under the right to education. And incidentally, the policy is contrary to the central government rules as well as the state government. That's our basic legal point.
Yes.
So the rules would be important.
Your lordship may see.
Yes, we have to see. We are not required to see the facts.
Right.
Facts can be seen separately at the executive level also. We are required to just examine the policy, the rules, and the act. Are we clear?
In case the state comes up with a policy which is in sync with the rules, then the petitioners could not have had any complaint. Incidentally, this issue is now pending before the Bombay High Court, where they have taken up this issue suo motu. Rajasthan has squashed on this distance criteria. So far as Uttarakhand, there is a status quo order, it is pending. Guwahati, they have agreed with the government and they have said that there cannot be any challenges to this kind of policy. But in Guwahati, the policy was not so glaringly contradictory to the rules.
Anyway,
This is the position so far as the other states are.
We will see.
So if your lordship now see straight away, my lord, 324. What was the finding of the learned single judge? My lords may kindly see, my lords. Page 324, internal page 70, paragraph 26. My lords have it, my lords. Page 324, paragraph 26.
Computer page 366.
Yes. Yes.
Similarly, Rule 6 of the Rules 2010 provides establishment of a neighborhood school that is in respect of children in classes 1 to 4. My lordships have it, 1 to 5. Within a walking distance of 1 kilometer of the neighborhood. Kindly note this, not 1 kilometer of the neighborhood. So far as children having classes 6 to 8, a school shall be established within a walking distance of 3 kilometers from the neighborhood. Rule 6, 3, 4, 5, 6, 7, 8 provides about the contingencies in which the area limits of the neighborhoods can be reduced. Kindly note, not the next line is very important. Therefore, a combined reading of the Act of 2009, the rules of 2010, nowhere there is any provision for merger / consolidation of primary / upper primary schools with the high schools. This is what is troubling. Therefore, my lord, why it is being quashed? Because a combined reading of the Act of 2009, the rules of 2010, nowhere there is any provision for merger / consolidation of primary / upper primary schools with the high schools. Therefore, the notification number so and so dated 11 March 2020 regarding consolidation of various types of schools, including high schools with so and so, with primary and upper primary school, is contrary to the provisions of the Act of 2009 and rule of 2010. That is the problem.
Yes.
As the very definition of elementary education as provided under section 2F of the Act means education from class 1st to 8. Therefore, the government has issued the notification number so and so dated so and so has been issued without taking into consideration the constitutional mandate as well as the statutory provisions of the Act of 2009 and rules of 2010.
Yes.
Now kindly see para 27. The table relating, I'm sorry.
Please.
The table relating to distance and enrollment norms for consolidation of schools in the notification of 11th March 2020, wherein secondary schools beyond class 8 have been given contrary to the Act of 2009 and rules of 2010. My lord, may I read this sentence again for your lordship's kind consideration? It says the table relating to distance and enrollment norms of consolidation in the notification dated so and so, wherein secondary schools beyond class 8 have been given contrary to the Act of 2009 and Rule 2010. Now, kindly note, my lords, the RT Act, subject to correction by my learned friends, stops at class 8. So, beyond class 8, there can be nothing where RT Act would have any application. So, therefore, the finding here is contrary, is on the face of it wrong.
Yeah.
So, any class beyond 8 is not within the purview of either the RT Act or the rules, and therefore this finding, my lords, is clearly vitiated. Now let me read further. In the table, a primary school having roll strength less than 40 in respect of a non-scheduled area.
No, the Act, it seems, does not talk of class standard. Rather, it talks of
Let me
age.
correct myself, my lords. If your lordship sees the Act, my lords, kindly see section
3.
2F,
2F.
elementary education.
8 class.
My lordships have
8 class.
8 class. And that your lordships will also get, my lords.
Beyond 8 is high school.
I'm
or
grateful.
beyond 6.
No, it is not covered under this Act, under the RT Act. Where is that? If your lordship sees, my lords, the preamble to this Act, an act to provide for free, my lordships have it, the Act,
Yes.
an act to provide for free and compulsory education to all children of age 6 to 14. And if your lordship sees, my lord, elementary education is defined. And if your lordship sees, my lordship is absolutely right, my lord. 3.1 is the relevant provision. I'm grateful. Every child of age 6 to 14 shall have a right to free and compulsory education in a neighborhood school till completion of elementary education. So therefore, my lords, in my humble submission, beyond class 8, this Act or the rules made thereunder have no application. So therefore, the finding in paragraph 27, to that extent, my lord, is clearly vitiated. May I read further? In the table, a primary school, my lord, I was reading page 72.
Yes.
In the table, a primary school having a roll strength of 40 in respect of non-scheduled area and less than 25 in respect of scheduled area can be consolidated is also contrary to the provisions of the Act of 2009, wherein it has been prescribed that classes up to 1 to 4, admitted children up to 60, 2 teachers are required, and therefore there is no minimum roll strength has been prescribed for a primary school under the Act of 2009 and rules of 2010. The notification number so and so fixing the minimum roll strength prescribed as per the table in respect of primary schools less than 40 in respect of non-scheduled area and less than 25 in respect of scheduled area is contrary to the statute. As such, the same cannot sustain in the eye of law. Now kindly look at page 319 of that judgment. That your lordships will get, my lords, at the internal page. I think our pages are different. If your lordship sees page 65 of that running page 65 of the judgment.
Yes, we are there.
Yes. My lord, what the table says is, it lays down the norm for teacher-student ratio. Like your lordship knows, my lord, law school, every school has that for this number of students, you will have this number of teachers. So what it says is, if your lordship sees the norms and standards, admitted children up to 62 teachers. That's the first one. So therefore, all that this says is that what should be the student-teachers ratio? It does not say that every class must have 60 students. Now, what the learned single judge says is not that because it says that a class should have 60 students with 2 teachers, your criteria of 40 or less is foul of that table. In other words, the learned single judge is saying that you cannot merge or demerge 2 schools on the ground that it has 40 students or less. But I was making a calculation. What is 40? Why 40 or why 20? So one class, I'm told, has 5 up, primary up to class 8, right? 8. So let us say there's a primary school for class 5 classes. So if you have 40, then look at the number of students are there in one class. My lord, would your lordship, therefore this central government calls them suboptimal classes. If your lordship sees one page, my lord, I'll just take your lordship. Huh? No, this was a chart. What kind of students were there in that school? Lordship may see page 155. Running page 155. Pull it out. My lords have it, my lords. It is page 155, annexure 1 to the repetition.
Yes.
Kindly see, my lords, the number of students in each class. The grand total says 7, 8, 5, 7, 6, total 33. My lords have it. And if your lordship see section wise, it is one student, 3, 3, 2, 3, 4, 4. That is why the central government calls them suboptimal schools. My lord, it is not, it is going to school. It is going to school to study with peers, competing. Therefore, my lords, the policy of the government of India that now you must rationalize schools.
Yes.
I was at page 326 minutes. So the first finding I showed to your lordships that rational mergers lack consolidation, not permitted under the Act. The second was beyond class 8 also you cannot do it because it violates the Act and the rules. The third was that 60 is permissible under the table. You can't consolidate anything which has 40. And the table in my humble submission was only telling us that for every 60 you must have 2 teachers. Would your lordships now kindly turn to page 328.
Yes.
Now, my lord, this is what my learned friend was addressing your lordships. Kindly see to the middle of the paragraph, my lord. It starts with besides. Besides that, my lordships have that line, my lords.
Page 74.
Page 74, I'm grateful.
Besides, yes.
Besides that, when the very purport of the Act of 2009 and rules of 2010 is to provide at least one school within a walking distance of 1 kilometer from the neighborhood, in that case, the state government cannot and could not take steps for abolition of schools which are already there and catering to the needs of the local people. Therefore, in the guise of merger/consolidation, the schools, the very purpose of the Act and rules are frustrated. Therefore, the impure notifications cannot. My lord, this finding is based on the assumption that you are merging 2 schools, the distance of which is 2.9 kilometers. This has nothing to do with the policy of merger per se. My lord, am I clear, my lords? Let me show you, lordships, what is Rule 6. Because we are all talking about Rule 6. It is quoted in the judgment. My lords may kindly turn to minutes. Just hang on.
Area limits of neighborhood.
I am grateful. My lord, if your lordship sees rule. No, first let us see section. We will come to rule.
Which section?
Section 3, my lord. At page, your lordship, it's quoted in the judgment. I will not trouble your lordship with the book. It is internal page 62 of the judgment. My lord, if your lordships want, I'll read it from the book also.
It is there. Yes.
So let us see what is 3.1. Right of child to free and compulsory education. Every child of age 6 to 14 years, including a child referred to in so and so, shall have the right to free and compulsory education. Kindly note, my lord, in a neighborhood school. The Act does not say any distance. It says in a neighborhood school. Since your lordships are here, kindly turn to page 64, the very next page, and your lordships will find, minutes. There is a section called 20. My lordships have it, minutes. Section 20, power to amend schedule. The schedule is the one your lordship saw.
This rule 3.
Yes, ma'am. Rule 3, section 3.
This rule 3 also refers to age of a child.
Right.
So suppose student is studying in class 3.
Yes, ma'am.
He may be 15 years old.
Correct. But what it says is that the age it says is age 6 to 14, and he must be receiving elementary exam. What I am supposed to give him, my lords? Elementary education. My lord, let me read it again. Every child of the age 6 to 14 years, including a child referred to in clause D and E of section 2, shall have right to free and compulsory education in a neighborhood school till completion of his elementary examination, education. And elementary education has been defined, my lords, in the previous page at F to mean from first class to 8th class. Your lordship may see, my lord, 2F.
Yes. Yes.
The rule has been quoted somewhere. Now, my lord, let us come to rule 6. And that your lordships will get, my lord, internal page 66 of the judgment. It was the case of the petitioners, respondents here before the learned single judge, that rule, the merger of these two schools had resulted in violation of rule 6, and therefore the merger was bad. Now let us see what is rule 6 means. My lords have page 66.
Yes.
It is at the foot of the page. The areas or limits of neighborhood within which a school would be established by the government or local authority. My lordships have it, notes. Kindly turn over the page, notes. In respect of children in classes 1 to 5, a school shall be established at a distance of 1 kilometer from the neighborhood. What your lordships will note is the distance is 1 kilometer from the neighborhood. Or in other words, there is a mandate under the rules that you must provide a school within 1 kilometer of the neighborhood. Let us read further.
So this is in respect of children up to class 1 to 5.
1 to 5.
Not
What?
6 to 8.
That is the next one, B.
B is next one.
In respect of children in classes 6 to 8, a school shall be established within a walking distance of 3 kilometers. My lord, here we are concerned with the first one, 1 to 5, 1 kilometer. No dispute, no problem. I will only show your lordship something more in these rules. Kindly see, my lord, 6.4. 6.4. My lordships have it.
Yes.
For children from small hamlets as identified by the government local authority, where no school exists within the area or limits of a neighborhood specified in sub-rule 1, the government/local authority shall make adequate arrangements for providing elementary education in a school in the relaxation of the limits specified under rule. The present case which we are dealing with is a case within 1 kilometer according to us. But there could be a case, a suboptimum school. It needs to be merged. Now it goes beyond 1 kilometer. And therefore, it says that there can be a relaxation. So 6.1 is also qualified by 6.4. And since your lordships are examining these rules, let us see what has been the central rules and what has been the model rules. When this act was made, they also gave a model rules for every state to follow.
But the model rules have no value.
Just as a guiding principle. Just as a guide. I'm not saying I'm relying on this. Just to show that where did I get this 4 from? This 4, which is relaxing 1, where did I get it from? And that your lordship will see if your lordship sees the model rule. It is rule 4, sub-rule 4. Because the government is very simple. You don't know that?
Yes.
If your lordship sees, 4 sub-rule 4 is at page 2. For children from small hamlets, my lordships have it.
Yes.
Sub-rule 4 of 4, page 2. For children of small hamlets as identified by the state government local authority, where no school exists within a kilometer or limits of the neighborhood specified under sub-rule 1 above, the state government/local authority shall make adequate arrangements such as free transportation, residential facilities, and other facilities for providing elementary education in a school in the relaxation of the limits specified under sub-rule 1. So therefore, page 67, my rule 4 is permissible. And therefore, I said, my lords, that these norms can be relaxed. Judgment. No. Yes. My lord, I next go to the finding on the GRF, on the grievance redressal forum. That your lordships will kindly see, my lords. It is at page 328, internal page 74, para 30. Notification which said that GRF. My lord, before I take your lordships to that, would your lordships be kindly pleased, Mills, to turn to page 205. This is an operating guideline.
Yeah.
If my lords are now, please kindly see, my lord. This is also 11th of March 2020. This has also been quashed. And this says subject implementation of guidelines for the policy of rationalization of school, rationalization and consolidation of schools. And if my lords are kindly pleased, my lords, to come to page 211. Kindly see paragraph 24. It is My lords have it.
Yes.
While the policy and the SOP has taken all necessary steps to ensure smooth implementation of the consolidation and the intent, if any, for the betterment of learning outcomes and environment of students. However, kindly note, my lord, however, if there are specific grievances by any party post consolidation in April 2020, the same shall be referred to the grievance redressal cell in the district office and then to the state grievance cell at OSEPA. The grievance redressal cell in the district office will be chaired by the district collector and constitute a team for in-person re-verification of each case. The re-verification on stakeholder consultation for each grievance shall be conducted by a person different from the original verification. Because somebody has given a report, he'll be different from this. A detailed copy of the investigation must be submitted to the state grievance cell, OSEPA. The state grievance cell may further investigate any cases it deems necessary. So therefore, madams, there was a two-tier post-consolidation grievance, something akin to what has been said, my lords, in section 31 of the Act, namely to inquire into the complaints. But since my learned friends are not on this question, my lord, I will not harp much on that. To come back to the judgment, I was reading at paragraph 30, page 328, internal page 74. If my lords are pleased to have it, my lords.
P
30. Page is 328.
Yes, 330.
74, para 30. By virtue of the notification number 5465 dated 11th March 2020, an alternative grievance redressal cell has been created, which can examine.
No, you are referring to paragraph
30, my lord.
30.
At the bottom of the page.
Yes.
By virtue of notification number 5465 dated 11 March 2020, an alternative grievance redressal cell has been created, which can examine the specific grievance of any party post-consolidation period. Is of no use, as once consolidation merger is made, any sort of grievance redressal by an alternative forum may lead to be an empty formality, as the grievance redressal cell is created by the government itself in the government offices. Government officers are members of the cell. Besides that, such grievance redressal cell in the district office or anywhere is contrary to the Act of 2009 and Rules 2010. Therefore, my lord, no reference has been made to any provision of the Act or any provision of the rules which prevents forming such a grievance. So my submission to your lordship is also, this is also not backed by any provision under the Act and the rules, which says that you cannot have such a forum. My lord, may I read further? Law is well settled by a catena of decisions of the apex court as well as this court that no man should be a judge of his own cause, which is violative of the principles of natural justice. Thereby, having a grievance redressal cell with some government officers, the petitioners will not get justice. Thereby, it is only an empty formality and eyewash for implementation of the notification as referred to above. And as such, the same is contrary to the provisions of law. Thereby, the interim notification of the government cannot be sustained. So these are the findings of the learned single judge, my lords, on the legality and validity of the policy. In my humble submission, subject to your lordship's kind consideration, the learned single judge has not cited any provision of the Act and rules which provide for such merger, such consolidation, and therefore this finding is completely wrong. Now we come to the case specific, the facts of the present case. Now let us see, my lords, paragraph 32 at page 330. Coming to the petitioner school, my lordships, have it minute. Page 76.
Yes.
Coming to the petitioner school in WPC number so and so, no doubt the student strength of the petitioner school was 33 for the academic session 2019-20. Your lordship may only make a note, madams, that undisputably this school has been in existence since 1954. Your lordship may make a small note, but it will have some relevance.
Yes.
And your lordships have also seen, my lords, the first merger happened on 14th of May 2018. That was a policy, your lordships. My lord, this school starts in the year 1954.
Which school?
This the coming to Amarmunda, 27401 of 2020. Amarmunda school. That is the only case which has been considered by this judgment.
Yes.
So, my lord, may I read this? Coming to the petitioner school in WPC number so and so, no doubt the student strength of the petitioner school was 33 for the academic session 2019-20, as the petitioner school was not given permission of students in respect of classes 1 during 2021. So, what was argued is that notwithstanding we applying in 2020 for academic session 2021 that admit a few students, 9 students in class 1, they were not given, which is a disputed question of fact. And therefore, had you given them admission, Amarmunda would have crossed 40, which is my threshold. Lord, am I clear, minutes?
Yes.
This school starts in 54. 9 students are sought to be admitted in 2020. And I mean, that's the case made out. And had you given them admission, he would have crossed 41 and therefore not been a candidate for consolidation. Let me read further. Had the permission been given to the petitioner school to admit class 1, student strength of the school would have gone beyond 40, as 9 guardians of the village were interested to admit their wards in class 1 of the said school. With regard to the distance, so this is one part. So this is one finding. Finding A. Now let us see B, minutes. With regard to the distance between Amarmunda Government Primary School and Lakshmanapalli Project Upper Primary School, the same is more than 1 kilometer. Rule 6 says, and section 3 says, there should be a school in the neighborhood. The state rule says it should be 1 kilometer from the neighborhood. So the consideration should have been that post consolidation, are you going beyond 1 kilometer from the neighborhood? What we are examining here is, what is the distance between the 2 schools? Am I clear? Okay, let me read it again. With regard to the distance between Amarmunda Government Primary School and Lakshmanapalli Project Upper Primary School, the same is more than 1 kilometer, that is 2.9 kilometers, which is evident from the Google map. The Google map itself has a disclaimer, not admissible in evidence, my lord, as your lordship knows, my lord. But in the counter affidavit, the distance between Amarmunda Government Primary School and Lakshmanapalli Project Upper Primary School has been shown to be 800. The same is beyond the actual fact available.
Students, well, whether all these students studying in this Amarmunda, they reside within 1 kilometer. Is there any policy?
Yes, madam.
That if you live beyond 1 kilometer, then you cannot be admitted in Amarmunda?
My lord, it says, my lord, so far as the facts of this case is concerned, it is our case that it is within 1 kilometer from the neighborhood. But your lordship asked me a larger question.
No, yes.
Your lordship asked me a larger question. Suppose there is a case where it is beyond 1 kilometer, then what happens?
No, suppose there are 3 schools.
Correct.
In an area.
I'm grateful.
One school, for certain reasons, has assumed prominence.
I'm grateful.
So therefore, the students from far
Will also come there.
places may if prefer
Will always come.
to come.
Correct. My lord, what is troubling your lordship is what is the relevance of the distance between the two schools? What is the correct question ought to have been considered is what is the distance from the neighborhood? Your lordship saw rule sections 3 said that you must have a school near the neighborhood.
No, the state has a duty
Correct.
to provide.
I'm grateful.
All right. So that decision can be taken whether you are providing or not based on again the cluster, the network.
I'm grateful. What we are addressing now is what is the distance between the two schools as opposed to what is the distance from the school and the neighborhood. But here what we are seeing here is a Google map. May I read it again. With regard to the distance between Amarmunda Government Private Primary School and Lakshmanapalli Project Upper Primary School, the same is more than 1 kilometer, that is 2.9 kilometer, which is evident from the Google map. But the counter affidavit, the distance between Amarmunda Government Primary School to Lakshmani Project Primary School has been shown as 800 meters. The same is beyond the actual fact and record available. My lord, what is this finding? On record, there are 2 documents, and I will show that to your lordship instantly. Kindly turn 2 minutes.
Page 2.
What is that?
218.
No, I want to show him that. Yeah, Google. Lord, let us see what was on record. And if my lords kindly turns to page 175, the petitioner relies on a Google map. No certification. My lords may kindly see page 175. My lords have page 175. My lord, no, not supported by any certificate under 65B of the Evidence Act, should have been discarded. That's my submission. And now my lordships have seen that map now. It's a Google map. And in contradiction, kindly see, my lord, what I have filed. The page.
Yes.
Page 218.
Annexure B1.
This is annexure B by 1 to my counter affidavit running page 218. Was I in the judgment?
Yes.
Kindly see, my lords. This is a verification form for identification of lead school. Name of the satellite school is Amarmunda. It has a code, UDISC code. This is a Government of India code. District is Bolangir. The block is Agalpur. My lordships have it, my lords. The block is called Agalpur. At the top of the page. My lord, the Chief Justice has it.
Yes.
And it is going to one school called, this is the GP Nuanpalli, and it is going to Lakshmanapalli. Both are in the same block, same district, and in the same Gram Panchayat. And let me tell you why it is so. If your lordship sees it, name of the satellite school, your lordships have seen it, Amarmunda.
Yes.
Just below that is district Bolangir. On the side of it is block Agalpur. And on the side of it is one GP called Uniapalli. And kindly look at the identified school little down, my lords. It is called Lakshmanapalli. My lordships have it. And kindly look at a little below that is Balangir. Block is same, Gram Panchayat is same. So it's in the same Gram Panchayat. And what is the distance? Distance from the satellite school is 0.8 kilometer. And it says, if the enrollment of the satellite school is between 21 to 40, then distance has to be less than 1 kilometer. And this is signed by whom, my lord? By the district education officer.
Yes.
And left-hand side, my lord, by the verification DEO. Now, please come back to page 330. So, the already single judge says, my lords, that there are two materials on record. One is an unverified Google map, which says 2.9 kilometers. One is a report filed by officers of the government, which says 800 meters. And if my lordship sees, my lord, last 4 lines, the same is beyond the actual fact available on record. Your lordships have that line. This is actually based on no evidence. The joint inquiry report has been placed as annexure B/1 to the counter affidavit, cannot be relied upon as the distance between the two schools is 2.9 kilometers.
Yes.
The further contention made in the counter affidavit that there is no natural barriers like ponds, rivers, deep forest, traffic, congestion between the lead school and is also not correct, as there is a reserve forest between the road leading to Amarmunda and Lakshmanpalli, and wild elephants are crossing the road frequently, which has come out in various newspapers stating that Amarmunda is adjacent to Chelia Reserve Forest. Therefore, at the caprice and whims of the authority of merger of schools has been made, which is disadvantage to the local. So, my lord, he relies upon, the learned single judge relies upon a newspaper report to say that there are elephants crossing the road frequently. Now, let us see what it is on facts. The newspaper report is at page. Lord, there are two newspaper reports. The one is at page 173. And my Lord Justice Raman will kindly assist your lordships in reading this. This has nothing to do with our case, nor the two schools. This has nothing to do with the finding rendered by the learned single. What I was reading? Where was I reading? Yes, paper 331. It says, my lords, that to one Chelia jungle.
No, computer wala 217.
217. Are we having different pages?
No, it's all right.
173. This is a newspaper report dated 20th of June 2020. And it says,
30th June. 30th June, Samaj.
Yes, 30th June, Sambada. And if your lordship sees, my Lord Justice Raman will kindly help my Lord the Chief Justice.
That is with regard to elephants.
Exactly. Nothing to do with this school, this road, nothing. This road, this school, between the two schools, between the nothing. It only says that to Chelia jungles, elephants have come back. Lord, I can understand, my Lord. This was saying that the road in which they have to go.
Elephant destroys crops of the village.
I'm grateful. I'm grateful. I'm grateful. So there's nothing of that kind. My Lord, this is subject to correction because the other newspaper is not readable. That is at page 174. It's completely blank.
No, but can we record findings on the basis of?
My Lord, I will leave it at that. I will leave it at that. The next question is, my lords, paragraph 33, page 78. No doubt the general principles of policy decisions are within the complete domain of the government. Necessarily, government shall exercise its own discretion but it is fundamental rule of exercise of discretionary power that discretion must be brought to bear on every case. Each one must be considered in its own merit. My lords, the learned single judge refers to several judgments. I will not trouble your lordships with all that, my lord. Let us straight away come to the finding. My lord, I have no quarrel that if a policy decision is in violation of the act, in violation of the constitution, obviously your lordship will strike it. There is no quarrel, my lords, that a policy decision is hit by the constitution or while in violation of some act, it has to be
Which
struck
page
down.
you are reading of the judgment? Not of the judgment, of the brief.
Well, Lord, I was now reading internal page 78, page 332, para 33, where my lord the single judge is dealing with the scope of interference to policy decisions of the state. My lordship, para 33.
Para 33.
33. No
70
doubt.
Page 78.
I am grateful. No doubt, my lord. The general principles of policy decisions are within the complete domain of the government. Necessarily the government. I'm sorry.
No, I have that.
I'm sorry. But as a fundamental rule of exercise of discretionary power, that discretion must be brought to bear on every case. Each one must be considered its own merits and decide on public interest requires the same. And then kindly now turn to, my lord, page 350, page 96 of the judgment, internal page 96. No, I will not trouble your lordships with that. Straight away come to page 355, 101. Page 355.
Yes.
Para 73 minutes. Keeping the above factual and legal aspects in mind, this court, in exercise of powers under judicial review, is of the considered view that the notification under Annex 3 and subsequent office memorandum so and so for implementation of the guidelines for policy rationalization and consolidation of schools, and also the corrigendum dated so and so, Annex A by 1, cannot sustain in the lie of law. Same are liable to be quashed, hereby quashed.
My lord, we have 58 students and there is a national highway between two schools and distance is 1.4 km.
ଆପଣଙ୍କର ପାଳି ଆସିନି ସାର୍ ଅନ୍ୟ ଆମେ ସରିନି ତାଙ୍କର ସରି
No, my lord, would your lordship now kindly come back to 158 for a moment, perhaps? Just a few clarifications. Page 148 is 158 is what has been quashed. Your lordship may see, minutes. 158 and kindly see 159. At the bottom of the page, there is a paragraph called H, which I wanted to show to your lordships. It reads like this: during consolidation, RTE distance norms for access to primary, upper primary schools may be followed. Alternatively, transport escort allowance as per RTE norms to be provided. And for the facts of the present case, my lords, Rule 6.1 applies in full force. Now kindly see the writ petition. Your lordships will get the writ petition at page 143.
Yes.
Kindly see, my lords, the first paragraph. The petitioner, who is the chairman of so and so in the district, has filed the aforesaid writ petition challenging inter alia the office order of the block education officer so and so, wherein basing upon the government order dated so and so, Amarmunda Private School has been directed to be merged with Lakshmanpalli, which is at a distance of 2.9 kilometers from Arun. The decision of the state government and the consequential order of the block education officer is contrary to Rule 6(1)(a) of the Orissa right of children to free education to compulsory education rules, which inter alia provide there shall be one primary school within a distance of 1 kilometer from the neighborhood. So this was the challenge. And kindly see paragraph 4. I had told your lordships, my lords, the school started in 1954. My lords will get it at the very next page, 147.
Yes.
And kindly see paragraph 5. The strength is 33. And then they say, my lords, that it is pertinent to mention here that this year the roll strength of Amarmunda Government Primary School is 33, as the authorities have directed the headmasters of the school not to give admission to the children in class 1 so and so, copy of so and so. Had admission been given in class 1, then certainly the strength of the school would have increased to 42. So 2020, a school is running from 54. Strength is 33. Because 40 was the norm, somebody wanted admission, not given, that is their case. And kindly now see, my lords, paragraph 8. The challenge is that the distance norm under Rule 6(1)(a) has been violated. That's the challenge. And if my lord sees, my lord, this is the whole case, and kindly see the prayer, my lords. The prayer also says, a writ of mandamus appropriated be issued, quashing the impugn order dated so and so, so far as relates to merger of petitioner school, Amarmunda Government Primary School. Said school may be allowed to run in Amarmunda without any hindrance, and the government notification of 11th of March 2020, which is my policy decision, is contrary to the Odisha right of children to free and compulsory education rules 2020. So no challenge that it is violative of the RT Act at all. And the counter also, if my lords will just see a few paragraphs, my lords, clearly says the counter affidavit begins at page 176 by the department, my lords, by the OP1. And if my lords are kindly pleased to see paragraph 7 at page 184.
Yes.
This clearly says, my lords, that the student strength is 33 and the distance is 800, well within the 1 kilometer norm. My lord, along with the counter, an additional affidavit has also been filed like B, like B. No, where is flag B? Kill. What is flag B? Huh? What is flag B? No, it's no. It's after the judgment or what? Any period. My lord, there is an additional affidavit, and it will be page 404 in my lord's brief.
Page 404.
404.
Only 360.
No. It was the Noata, old one. It was filed before the learned single judge. It is page 404. It is in writ appeal 417 of 2021.
In writ petition.
Writ appeal, my lord, 417 of 2021. It will be, my lord, page 404, flag B.
Yes.
It will be PDF 404, flag B. My lords have it, my lords. And the date of this affidavit. My lords have, my lordships have it, my lords.
24/6/20. Yes.
22/6/2020.
Additional affidavit by Alok Kumar Kar.
I'm grateful. I'm grateful to you. If your lordship see internal page 3. Well, I'll not trouble your lordships with all that. Kindly straight away come to page, internal page 10, which is the National Education Policy of 2020. My lordships have it, my lords. Internal page 10.
Annexure 7.
Yeah, Annexure 7, I'm grateful. It is called National Education Policy 2020. And if my lords are kindly pleased to turn 2 minutes. Internal page 38, paragraph 7.
Yes.
What was falling from your lordships is not captured here, clusters. Efficient resourcing and effective governance through school complexes / clusters. May I read para 7.2 minutes to save time?
Yes.
These small size schools have rendered it economically suboptimal and operationally complex to run good schools in terms of deployment of teachers as well as provision of critically physical resources. Teachers often
You are reading 7.2.
7.2.
Small schools.
I'm grateful, dear lordships. My lord, may I read the first one also? May I read 7.1?
Yes.
While establishment of primary schools in every habitation across the country, driven by the Sarva Shiksha Abhiyan, now subsumed under the Samagra Shiksha scheme and other important efforts across the states, has helped to ensure near universal access to primary schools. It has also led to the development of numerous small schools. According to so-and-so data, nearly 28% of the India's public primary schools and 48% of India's upper primary schools have less than 30 students. My lordships have that line, minutes?
Yes.
The average number of students per grade of elementary system, primary, upper primary, grade 1 and 8 is about 14, with notable proportion having below 6 during academic session 16-17. There were 1,08,007 single school teachers, majority of them 85743 being primary schools serving grades 1 to 5. These small school sizes have rendered it economically suboptimal and operationally complex to run good schools in terms of deployment of teachers as well as the provisions for critical physical resources. Teachers often teach multiple grades at a time and teach multiple subjects, including subjects in which they may not have any prior background. Key areas in such as music, art, sports are too often simply not taught, and the physical resources such as labs, sports equipment, library, books, etc. are simply not available across schools. The isolation of small schools also has a negative effect on education and the teaching learning process. Teachers function best in communities and teams, and so do students. Small schools also present a systematic challenge for governance and management. The geographical dispersion, challenging access conditions, and the very large number of schools makes it difficult to teach all schools equally. Administrative structures have not been aligned with the increase in the number of schools or the unified structure of Samagra Shiksha scheme. Although, kindly see 7.4, very important. Although consolidation of schools is an option that is often discussed, this must be carried out very judiciously and only when it is ensured there is no impact on access. Such measures are nevertheless likely to result only in limited consolidation, to not solve the overall structural problem and challenges presented by the large number of small schools. These challenges will be by 2025 addressed by state and union territories by adopting innovating mechanism to group or rationalize schools. The objective behind this intervention will all be to ensure that every school has an adequate number of counselors, trained social teachers, shared or otherwise, for teaching subjects including art, music, science, sports, languages, vocational subjects, adequate resources, shared otherwise, a library, science labs, computer skills, etc. Melody, Lordship may leave it. Now kindly see 7.6. One of the possible mechanisms of accomplishing the above establishment of grouping structure called school complex, consisting of one secondary school together with all other schools offering lower grades. This suggestion was first made in the Education Commission in 64-66, but was left unimplemented. This policy strongly endorses the idea of school complex clusters wherever possible. The aim of the school complex cluster would be greatly resource efficiency and more effective functioning and coordination, leadership, governance, management of schools and clusters. Kindly see the next paragraph note, and I'm done with this. The establishment of school complex clusters and sharing resources across the complex will have a far number of other benefits such as consequences, improved support of children, disabilities, etc. etc. Leave it at that. So, my lord, even in 2020 policy, they also talk of consolidation of schools. And therefore, this is not something which is alien to the RT Act or the RT rules. I'm troubling your lordship with lot of...
Black.
My lord, there is one affidavit which has been filed on 18th of March 2024. It will be flag 1-3.
Flag
1-3. The whole idea is, my lord, since these are pending in different courts, my lord, your lordship may ask me what I am to show. If your lordship sees this affidavit,
Towards the end.
Ashwini Kumar Mishra.
yes, I'm grateful. Yes. Just see, kindly see, my lords, paragraph 3. That my lordships have it.
Just
Yes, I'm sorry.
Yes.
Lord, para 3, that pursuant to merger of schools in the states of Jharkhand, Madhya Pradesh, Rajasthan, Orissa, Niti Aayog, the nodal think tank of the Government of India, conducted detailed empirical analysis of the outcomes of policy of merger of schools and published a detailed report on the findings of learnings of large-scale transformation in school education. The aforesaid report has found policy of merger of schools to have conclusively improved the learning outcomes of students. Merger of schools have improved the access of quality education. Let me take your lordship straight to the report. The report starts at internal page 6. Your lordship may skip all those messages. Kindly straight away come to, my lords, page 23. My lord, this is the executive summary of a project now called SATHE approach. It says interventions and learnings. So project SATHE, my lords have page 23, my lord. Project SATHE, Sustainable Action for Transferring Human Capital Education, was started by the Niti Aayog in 2017 with the object of supporting 3 states to undertake a system of wide transformation effort with central focus towards improving quality. Your lordship may skip all that and straight away come to 25. Page 25. Odisha was one of the states that was earmarked for this. In terms of the actual intervention, my lordship said page 25. In terms of the actual intervention, each state roadmaps had initiatives in 3 categories of reforms: structural reforms, academic reforms, governance and accountability reforms. We are presently concerned with structural reforms that your lordships will see, my lord, is 1. My lordships have it. And there it says school consolidation for optimal enrollment. So therefore, my lord, school consolidation is a part of the national policy and not prohibited under the RT Act. And if your lordship sees that same page to the bottom, where we have gone ahead and done a lot of consolidation. Performance in Performance Grading Index, PGI, my lordships have it, right-hand column towards the end.
Yes.
It says, last but one paragraph, Odisha moved up 2 levels from grade 3 to grade 14. My lordship may now kindly see page 29. What do you want me to read? Page 29.
Yes.
Yes. So then come where? Page 33. My lords may kindly see page 33 minutes. Whom will we go? Where is that? If your lords kindly see page 33 minutes, structural intervention, strengthening of schools delivery system, school consolidation. In India, an average government school has 50 to 60 students and 2 teachers, while its private counterpart has 265 students and 9 teachers. There are nearly 4 lakh government schools with less than 50 students and just 1 or 2 teachers. We consider such schools subscale. Lordships have it? Subscale, that is, they do not have the size, capacity, or resources to deliver high quality education. So even 50 is considered to be subscale. We have here said 40 in our policy.
Yes.
Why? My lords may now kindly similar 2-3 more pages. Page 253. I'm sorry, Millers, 252. If my lords are kindly pleased to see page 252 minutes.
Yes.
It says supporting case study Odisha.
Yes. 252 is something else.
Miller 252.
252
252.
of the writ appeal.
No, of this report.
Oh,
I'm so sorry. This additional affidavit, your lordships, you will now see. 18th March.
The annexure 10.
Yes, great. Annexure. No, my lord, the affidavit I was just reading to your lordships.
yes, yes.
That's Sate.
Yes.
Yes. If your lordship sees
Additional
252 minutes,
Flag
252.
13.
It says supporting case study Odisha. It is annexure 10. My lords were right. Your lordships have it.
253.
252 it starts supporting case study
Supporting case
Odisha.
study Odisha.
And 253, my lord.
Yes.
It says government schools are 1/3 the size of private schools. And implementation, just below that, my lords. It says schools consolidation has been carried out in a phased manner in Odisha since 2017. Your lordship saw the first policy was 2018. Divided into 2 phases. First one in 2017, 2018, 2022, and 4th phase is yet to commence. And if your lordship sees, my lord, under 2018, it says policy issued in May 2018. May 2018 is what your lordship saw in the beginning at page 127. It says 2148 schools were identified for physical administrative merger. 101 school, my lordships have it, my lord. I'm just reading below that, completed in 2018. Page 253.
Yes.
So it says policy issued in May 2018. 2148 schools identified for physical administrative merger. 101 schools merged as per the report of so and so. Kindly look at the next one, my lords. Page 3. 15,000 schools identified. 6,222 schools in the final stages of consolidation. The submission to your lordship is this, minutes. That merger of schools per se has always been in sync with the RT Act, and therefore merger as a concept is accepted nationally. And therefore to say that your policy is bad because it runs contrary to the RT Act and the rules made thereunder, in my humble submission, my lord, is not sustainable. My lord, just one more page. And kindly see, my lord, the last page of that affidavit, page 364. Okay.
264.
Yes, my lord. 364. 364. The last page.
1415. That is computer. Status of merger of.
I'm grateful. I'm grateful to you. If your lordship sees the last column, 7750 were approved. My lord, the Chief Justice. 7750 were approved. 5633 were merged.
Please.
Correct. And my lords, demerged were 43. Pursuant to the GRF, grievous resolution mechanism. So it is not to say, my lords, that after some school has merged, it has not been demerged. 43 schools have been demerged when they have shown that the merger is in contravention of either the rule or in contravention of the resolution. So in my humble submission, my lords, that is the efficacious remedy available, inbuilt in the operational guideline. My lord, I'll show two more pages and then double facts. If your lordships kindly come back to page 148, my lord, my apologies, my lord, I'm taking your lordships back and forth. 158. Put it. Page 158.
158 of
158 of the writ appeal.
Same.
I'm grateful. I'm so sorry, my lord. I should have shown
Writ
the
appeal.
of the writ appeal. And 158 is an annexure to the, yes. 158 it starts. It is 11th March 2020. And if my lords are kindly pleased to come to 159, your lordship may see, my lord, small a at page 159. It says government elementary and secondary schools having enrollment less than or equal to 20 to be consolidated with the nearby schools, irrespective of the distance. Your lordship may read in 6-1 there to mean 1 kilometer. Your lordship may take it from it. And at the foot of the page, minutes, it says during consolidation, RT distance from access to upper primary schools may be followed. Your lordship may say shall be followed. May has to be read as shall. Lord, I'll just show a few paragraphs of two judgments and then I'm done. This is 2021, volume 17 SCC.
Yes.
Page 1. Their lordships were concerned with disability children.
I just heard the learned advocate general say that within 1 kilometer distance, that's a giveaway that he's saying.
It is.
If it is a giveaway, then they have to come up with a new policy.
Why is that?
Because on that ground alone, the policy.
I'm sorry.
No, if he's saying that this policy will be changed to.
No, I'm not saying any policy. I'm saying that everything has to be compliant with according to the act and the rules.
No,
which says 1 kilometer.
as we will be open to discussion because it involves public interest. It's like to ensure that the tender hearts are not made to compelled to go to more than a kilometer, or it cannot be a circle. When you talk of within the radius, so radius not within the meaning of the radius of a circle. So if someone does that, then there will be vacant spaces among four circles. That is not the idea. The idea is that if even more than less than a kilometer, like more schools, but and as in this case, because there are two aspects, you decide a list based on the facts. So here there were two schools and merger. All right.
In fact, there are about 120.
All right, 120. So when we address two schools and we take like in this case, the distance according to you was 2.9 kilometers.
Right.
According to them, it was
0.8 kilometers.
0.8 kilometers. You don't know the actual location of the habitation from where the children are coming to one school and going to another school. So it is difficult if the policy on the face of it is contrary to any statutory provision, yes. But on the ground, it is very difficult for the courts to enter into. That's the idea. And when there is a grievance redressal, if the grievance redressal is not an appellate forum or not a forum above the government, it's internal mechanism. And the courts must believe that the governments are not against public.
I'm grateful.
Why any government or why any they shall go against government? Public interest, they have also to safeguard.
I'll wait for my
Nevertheless, if any action of the government or if any action of any authority is found to be in conflict with any statutory provision, we have a duty. But we cannot presume that their actions are contrary to public interest intentionally.
Let the learned
Let us
Advocate
see.
General complete.
All right.
I'll wait for my turn. If there was because this distance criteria of 1 kilometer and 3 kilometers, that is basically the crux of this case. I'll wait for my turn.
Yes. Please.
Yes, minutes. So I was citing this judgment, 2021, volume 17, page 1, only for the limited purpose of submitting to your lordship's minutes that this National Policy 2020, which I just read to your lordships, has also been taken into account by the Honorable Supreme Court to decide cases. That is not as if it is something not to be considered. And that your lordships will get at internal page 58, paragraph 63, where 7 is quoted copiously. And I will not trouble your lordships with that, lords. If your lordship sees, my lords, paragraph 63, page 58. My lords have page 58 minutes.
Yes.
Kindly see, my lords. At the bottom of the page, another relevant portion of the scheme. My lord, may I read 63? Besides the above mentioned scheme, Ministry of Education, formerly known as so-and-so, Government of India has formulated a National Education Policy 2020 dealing with the gamut and quality of gamut of aspects, including strengthening of dispensation to deliver free and inclusive and quality education, the neighborhood school to all between the age of so-and-so, while referring to the teaching of schools in so-and-so, so-and-so. Your lordship may now see, after that, special educators kindly come. Another relevant portion of the scheme is clause 7. Your lordship just saw clause 7. I read clause 7 to your lordships. They quote whole of 7 at pages 59, 58, 59, and also 60. My lords have it, Now kindly turn to minutes, page 66, paragraph 72.7. The authorities may also, my lordships have that paragraph.
Yes, please.
The authorities must also explore the possibility of merging unviable special schools with relatively viable special schools in the neighborhood so as to entail consolidation of assets, resources for better quality of the requirement of students. So therefore, my lords, merger has also been approved by this Honorable Supreme Court based on their policy. Two.
Yes.
Lord, to sum up, minutes, it's my humble submission, and this is for your lordship's kind consideration,
Yes.
that the learned single judge has quashed the policy on the ground that the same violates the provisions of the Right to Education Act. In my humble submission, my lord, no provision of the RT Act has been indicated which is violated. And in the alternative, my lord, there are in fact no provision of the RT Act which says that there can't be consolidation of schools. Point 2 minutes. It has been the policy decision of the Government of India from various reports, as your lordship saw, Niti Aayog, National Policy, etc. minutes, which says that schools must be, suboptimal schools must be consolidated. On the facts of the present case, although 100 some cases were filed under the fact of only one case was examined. That is the Amarmunda school. In the whole judgment, your lordships will not see any other facts having been discussed. All that it says, may not that this judgment will apply to all other cases. Now, Amarmunda was a case where the discussion in the judgment proceeds on two reports, one being a Google map, which says 2.9, unverified. Other being a report which says 0.8. If it is 0.8, being the distance between the two schools, then 6.1 does not apply is what the petitioners say, because the petitioner's case is that since the distance between the two schools is 2.9 kilometers, therefore Rule 6 has been violated and therefore the policy is bad. In my humble submission, if it has violated, assume it was not 0.8 and assume it was 2. The policy does not get vitiated. Implementation of the policy gets vitiated. The policy is I will merge two schools. Obviously, I will maintain the distance as per Rule 6.1. The policy cannot be vitiated because Rule 6.1 has been violated. Because the policy intends to work within the four corners of the statute. One may say that implementation of your policy is wrong, but that is not to say that the policy is wrong. And we have provided for an internal mechanism. For some reason, my lord, as they say, that the distance between the two schools, which according to me is not a relevant consideration. One could come and tell the GRF that, look, The distance between the new school is beyond 1 kilometer from my neighborhood. It is violating Rule 6. Please put me back to that. As your lordship saw, 42 or some odd schools have been done. It is nobody's case that we went to the GRF, we pointed this out, whatever was the grievous mechanism, and we have not been restored. But that is not to say, my lords, the policy is vitiated. The policy nowhere says that there
How
can
many districts are involved in this case?
5. My lord, 5 to begin. My lord, I'm deeply grateful for a very patient here.
Just give us the list of districts.
Yes, my lord, I will give you that.
And the specific schools.
Yes, my lord.
Which have been shifted from.
I'm grateful.
And short notes also.
Yes, ma'am.
Ask your junior.
Yes,
to
yes.
prepare.
We have given a short convenience note, which is at flag 12 of your lordship. Now, before that, if my
Oh, this matter was heard at length earlier also, no?
It was.
When flag 12 is there.
Granting stay, we were trying to oppose stay. So it was heard at some length. Now, here, if my lord would see the impugned judgment, a batch of cases have been.
Before that, before you begin,
My lord,
let us understand which scheme, which provision of the scheme violate which
route.
Route.
Well, straight away, I'll come to my convenience note. Within a short time only, I'll be able to show it.
Please.
My lord may see flag 12.
Yes, we have.
Now, the question formulated, I just wanted to show the impugned judgment specifically formulates a question and answers it. Should I show that, my lords? It specifically formulates that whether this policy, impugned policy, there is one policy which is impugned, whether the impugned policy contravenes the state rules and the act or not. That is the question formulated.
Yes.
And here I must say, there is also a central rules. In accordance with Section 38 of the Right to Education Act, Section 38 empowers rulemaking. State has come up with a set of rules. Central government has also come up with a set of rules. The central government rules somehow have not been taken note by the Honorable Single Judge, but those rules under Rule 6 also specify this distance criteria of 1 kilometer and 3 kilometers from 6 to 8. So it is this distance criteria which actually would enable this court to strike down this policy. I'll show the policy straight away. My lord may come to that convenience note at flag 12.
First of all, show us the rules.
My lord.
Then we can understand the.
My lord. That would be at page 6 of
the policy.
Page 6 of that convenience note. It was a part of all these writ petitions and also it's annexed to the writ appeal. But for convenience, I have annexed it to my convenience note again. So this is the policy. It's an executive instruction. It is not a rule or anything. It's an executive instruction. Now, my lord may kindly see it's dated 11th March 2020. Subject is rationalization and consolidation of schools. Now, my lord may kindly take note of this word consolidation.
Yes.
It's being repeated again and again. It's in addition to the earlier policy of 14th May 2018. The objectives of such a policy have been elucidated in said notification in view of the immense benefit of such consolidation provides in terms of improvement of quality of education, efficient utilization of state resources. There is continuous endeavor at the level of government to further strengthen the policy of so and so. Now, the details I'll come to that, but basically this policy is, if my lord would see the objective number 1 at page 6 itself, towards the bottom, the objectives of the policy are as follows. First, serial number 1, to reduce the number of educationally and economically suboptimal schools. I'm laying emphasis on this word reduce.
Yes.
Now, what would be squarely contrary to the central government rules and the state government rules would be the principles at page 7, serial number A of that. If I may read that, my lord, the heading is capital A, Consolidation of Schools Principles. I hope my lords got
Yes.
that. The exercise of consolidation is to be conducted in a manner so as to ensure optimum number of schools with optimum enrollment, create as many integrated secondary schools as possible, and convert all other schools having reasonable enrollment to any of the 4 categories of schools as mentioned in the objectives of the policy. In the set of 2 or more schools identified for consolidation under this policy, 1 school will be identified with the other schools will be consolidated. These schools will be referred to as the lead school. The other schools which will consolidate with the lead school will be referred to as satellite schools. In order to achieve this, the following kinds of consolidations are to be taken up. Now, this serial number A would be very important. Government elementary and secondary schools having enrollment less than or equal to 20 to be consolidated with nearby schools irrespective of distance. This clause, I may pause here, my lords. Now, my lord may come straight away to the rules. I'll come to the other provisions, but this would completely override the statutory rules which are there at page 14 of that compilation. This is the state rules which the Honorable Single Judge has referred. Page 14.
No, but whether single judge has referred to this rule, 1A.
My lords.
1A has been
1A of the policy.
1A of the scheme has been referred to.
Yes, it has been referred to. Not only that, the table, everything has been analyzed. There's a table also, for, which is there. But I'll come back to that. I just wanted to show that on a standalone basis, this principle 1A, which I just read out, would run contrary to their own rules.
Yes.
What is important is the rules. Now, that would be at page 14.
Yes.
Page 14 of that compilation. May I place that, my lords?
Yes, please.
The notification is dated 27 September 2010. In exercise of the power conferred under section 38 of the Right to Free So and So Act, the state government do hereby make the following rules. Now, my lord may kindly see thereafter rule 6 on the next page, page 15. Duties, responsibilities of the government, local authority, areas or limits of neighborhood. Now, this neighborhood has been italicized. This would have some relevance, my lords. I'll come to that. Now, clause 1 of 6, rule 6, the areas or limits of neighborhood within which a school would be established by the government or local authority shall be as under. A, in respect of children in classes 1 to 5, a school shall be established within a walking distance of 1 kilometer of the neighborhood. So, my lord, the policy squarely contravenes this rule of the state government itself.
Yes.
Now, then, my lord, the next B, in respect of children from classes 6 to 8, a school shall be established within a walking distance of 3 kilometers of the neighborhood. Now, my lord, may kindly take note of the word shall. The rules mandate that it shall be established within this much distance.
Yes.
Now, what I read out from the policy, it is irrespective of distance.
Yes.
So, my lord, on a standalone basis, in black and white, I can show that their policy contravenes their own rules.
Yes.
Now, if I may show at this juncture, it will be very important to see the central government rules which have been formulated pursuant to section 38. That is not a part of these records.
Central government rules are there.
Part of the Honorable Single Judge somehow didn't take note of the central government rules.
All right.
My humble submission would be that this makes it still worse for the state government.
Right.
Now, my lord, may kindly see Rule 6 of the Right to Free Education Rules 2010. Same under section 38 it has been made. Now, my lord, may kindly see. areas or limits of neighborhood, the area or limits of neighborhood within which the school has to be established by the appropriate government or the local authority shall be A, in respect of children in classes from 1 to 5, a school shall be established within a walking distance of 1 kilometer from the neighborhood. Then, my lords, B, in respect of children from 6 to and so 3 kilometers from the neighborhood.
Yes.
Now, there is some, it's not a copy paste job. So, state government rules have modified some portions. Like in clause 4 of rule 6, the central government rules specify that you have to provide free transportation in case you are beating the 1 kilometer distance. Free transportation and residential facilities is mandated in under the central government rules. This, the state government rules have not, it's not there.
No, but sub-rule 4 carves out an exception.
My lord, it starts from an exception.
It carves out an exception to rule 1.
My lord, it carves out and then the condition specified. For children from small hamlets as identified with the appropriate government or the locality where no school exists within the area limit so and so, the appropriate government or the local authority shall make adequate arrangements. Now, this next phrase has been deleted in the state government rules. But that's it, besides the point. This was not the subject matter of consideration in the before the single judge. Now, the state government removes such as free transportation and residential facilities in their own routes. The point before the honorable single judge was that whether you can have a policy which contravenes the state rules itself. And the single judge in various paragraphs has discussed that and has said that since your policy contravenes your own rules, relying on a number of Supreme Court judgments, the honorable single judge has struck down their policy.
And single judge has not referred to Supreme Court judgments on this point. The Supreme Court judgments which have been referred to are on different issues, not on this issue.
No. The honorable single judge has
and we may not agree with your submission that this rule 6, which is rule which rule is this of the state?
6, same number.
Rule 6. Rule 6(1) is so mandatory that in no case it can be deviated from because of sub-rule 4. That is there can be a circumstance, particularly in difficult areas.
In fact, they have identified what would be difficult areas, difficult terrain. That is there. The rules also formulate that. If you have difficult terrain, the central government rules say that you have to provide free transportation. But the policy which has been formulated by the state government here, it doesn't proceed on that footing. They proceed now, my lords, why, if I have to support the order of the honorable single judge, my lord may proceed.
No, that you will have to.
My lords, I have to submit this, my lords. The policy which was impugned there, that proceeds on a footing of strength of students. The major criteria in that policy is strength, enrollment.
No, but how do you say that this...
my lord may see the policy.
You were referring to sub-rule 4
my lords,
of the central rule,
my lords,
and sub-rule 4 of the state rule. What is the... Oh.
My lords, this portion has been deleted.
Just
free transportation.
No.
The convenience compulsion.
That's I can enlighten your lordship.
Same, I think.
No, my lord may kindly see the
come to sub-rule 4. What is there?
Now, so state
that
government
make arrangements such as free transportation, sport facilities, and residential
my lord may kindly
facilities.
see that.
This is there.
At page 15 of my note, the state government rules are.
No, do you have the book with you?
The state government rules would.
Perhaps you are wrong, because you have submitted in your compilation 2010 rules.
Which have been, I'm not sure if they have been modified. Then I stand corrected. Then this
Which you say.
free transportation and residential facility.
Yes, it is there in the rule.
I'm so sorry.
Arrangements such as free transportation, escort facilities, and residential facilities for providing elementary education. in a school
I'm so sorry,
and
Manoj.
relaxation of.
I'm so sorry, Manoj. In fact, I might have the amended one. I have not. That's my mistake. Manoj. But Manoj, the basic point which fell.
All right, we will hear you tomorrow. Just a minute. All right, we will take up this matter at 2 p.m. tomorrow.
My lord, lordship pleases.
Another case is fixed at 2 p.m. tomorrow. That case will be taken up after this case is
I'm
concluded. Hearing of this case is concluded.
I'm grateful.
But in the meanwhile, I would like to hear him also. We would like to hear him. What is your? क्या है बताइए?
My lord,
हाँ.
in our school, the enrollment is now 58.
हाँ.
58 students.
हाँ.
And the distance is 1.4 kilometer. And their national highway 650 I think passing. Then please, why our school is not open?
दे दीजिए वो उनको.
दे दियो तो कौन लिख के आने दे दियो.
वो एक बात सुनिए, वो आपके पास जो कागज है ना, वो मिश्रा साहब हैं, सीनियर एडवोकेट हैं यहाँ के बहुत बड़े. आप वो कागज दे दीजिए, वो बता देंगे कोर्ट को. ठीक है, और आप चिंता नहीं करिए, आपकी बात वो रख लेंगे.
I mean, pardon me, item number 25 may kindly taken up tomorrow.
All the matters will come. We are sorry that
Argument was over. Item number 55. In morning also I mentioned that. Argument is over, maybe top of the list.
we will see.
Item number.
Let it come. We are a bit slow.
Argument is go over from the both sides.
All right. Let the matters come.
Item 56. Not tomorrow because I have personal inconvenience on any day.
Just we will see. Your matter will be at